Hi, my name is Aaron Lacey, and you are listening to the U.S. Department of Education's new Financial Value, Transparency, and Gainful Employment Rule, which is a webinar brought to you as part of Thompson Coburn's Higher Education webinar series. While folks are coming online, I thought I'd go ahead and go through some housekeeping. First of all, you'll notice around the borders of the screen there are various little widgets with which you can interact. The Q&A widget is a place where you can enter your questions during the webinar. There will be a Q&A segment at the end of the webinar if you're watching on November 7th. So we'd be delighted for you to enter questions while I'm speaking, and then we'll try to get to all of those at the end. There's also a resource widget there on your screen. There's a copy of today's slide deck in that resource widget. Would really encourage everyone to download that. As you'll see throughout the presentation, there are many places where we have included live links, which will take you to underlying resources, so you'll want to have that slide deck on hand. Also, we're going to cover a lot of material today, and I'm sure as it washes over you, you may think to yourself, boy, it'd be nice to have something to refer back to after this presentation is done. There's a help widget which may have answers to technical questions that arise during the presentation, and encourage you, if you experience some sort of technical issue, to maybe check that out. This webinar is accredited for continuing legal education in certain jurisdictions, and in the resource widget we have included a document that refers to the CLE accreditation. It tells you which states it's accredited in and the exact time periods for which it has been accredited. Just keep in mind, if you're an attorney and you're trying to get continuing legal education, we do award that based on your attendance throughout the entire webinar. I'll also highlight that during this presentation there are going to be various secret words that appear, and you'll actually see, so you can see now the slides and my picture. Just to the side there will be a child box that pops up on your screen, and it'll have some little radio buttons, and the secret word at each point during the presentation will be one of the options. And so please make sure to watch and to click on that radio button, because we want you to get your continuing legal education. And finally, following the webinar, as always, there will be a post-webinar survey, and we are deeply grateful for the folks who take the time to respond, and particularly to put in comments. We really do try to make every webinar better than the one before. Thompson Coburn, if you don't know us, if you happen to be joining us for the first time, is a law firm here in the United States. We're pretty big. We have over 400 attorneys, and we have offices around the country, headquartered in St. Louis, but sizable offices in other major markets, as you can see here. We also have a higher education practice within the firm, and what that means is we have attorneys who spend all or most of their time working with institutions of higher education, and occasionally with entities that serve institutions of higher education. It's a very broad practice. We do a lot of things for colleges and universities. We sort of say here on the slide, specialized corporate regulatory litigation services, but the key there is specialized. We have a group of practitioners who have spent time in higher education, who have dedicated their careers to higher education and understand what's unique about your institutions and also the regulatory environment in which you operate. I will note my marketing team put together a neat little map here that shows the main campuses of many of the clients that we represent. There are still a few states where we don't have a client yet, so to my friends out in Fairbanks, this is an opportunity for us to put a dot on the map. Let me know. Give me a call if you'd like to chat. One of the things we do in addition to providing legal services to clients is we work very hard to create higher education legal resources for the higher ed community, and this webinar is a perfect example of that. On that topic, by the way, I'll note that this is the first webinar that's part of a two-part series. We'll be doing another one and releasing it about a week later. We anticipate on November 14th, and it will focus, this is a general webinar where we're talking about this new rule sort of in all the different parts of it. In the next webinar, we'll be focusing very specifically on how institutions can project earnings, debt to earnings rates, and some of the other metrics that the department's going to be using as part of this rule. And we'll be walking through a 9-part process. So we'll be really getting deep into the calculations in the subsequent webinar. We'll also be putting out a desk guide that goes through that multi-step process, and again is designed to really help schools who want to try to project and anticipate how their programs are likely to perform under this new rule, help you understand how the mechanics of those calculations work and how you can actually go through and potentially project program performance. So, like I say, we're very committed to this idea. We created a website last year. We had all these blog posts and white papers and webinars, and we thought, we should really create a single place where they are all together. So we've done that, and you can get to our higher education resources page either by scanning the QR code right there or by just simply going to thompson-coburn/higher ed. The presentation today is going to be delivered by me. Often we try to make sure we've got a number of folks involved in our webinars, but it just so happens that this particular rule is a focus and has been a focus of my practice for 13 years, far too long for anyone to be focused on this particular rule. So I'm Aaron Lacey, and I'm the chair of our higher education practice at Thompson-Coburn. And again, my practice, like the practice of our group in general, is fairly broad, but one of the things I tend to really focus on, a core area of expertise, is federal higher education regulation and policy. And again, the Gainful Employment Rule and what is the current version of the Gainful Employment Rule, which is the Financial Value Transparency and Gainful Employment Rule. Actually, I will just very briefly on that note. I've had some people ask me, they say, well, I heard you talk about gainful employment. When are you going to talk about financial value transparency? Just to be very clear, this is one rule. So the financial value transparency and gainful employment rule is one big rule package. So today's webinar is covering all of that. Here's the syllabus. So this is what we're going to be talking about. And again, this is intended to be a comprehensive soup to nuts discussion of this new rule. We hope that you will find that it is one of the best webinars you'll see and one of the most thorough. Our goal was really to give you something that when you came away taking this and maybe the other webinar and the desk guide, you and your colleagues could have a really strong sense as to what this rule is about and that you have the tools now to develop an action plan, because there are things that institutions are going to need to be doing. So first, we're going to talk about the road to financial value transparency, meaning I'm just going to give you a little bit of background on how we got to where we are right now. We're going to discuss the new regulatory framework, and by that I actually mean in the regulations themselves, how the sort of new rule has been created and divided up. We're going to talk about DE rates and the earnings premium, which are the two sort of core metrics at the center of this entire regulatory framework. We're talking about reporting requirements, which are really significant and meaningful for institutions and something you'll want to get on top of sooner rather than later. Then we'll take sort of a step back and talk about, okay, what's the annual process? The new department program information website, disclosures and distribution requirements for schools, and then the consequences of failure. So the department's going to be calculating these new rates, this debt to earnings rate and the earnings premium. And if your program is not performing well, there are consequences, and that includes for all institutions of higher education. Finally, we'll talk a little bit about GE program certifications and give you some advice on timelines and action plans. So we've got a lot to get through today. I would say take a deep breath, settle in, grab a glass of water, maybe some popcorn, whatever suits you, and we'll walk through this in a methodical way. And I'll also just say, it's a lot to take in, particularly if this is your first exposure to this new rule. So, let it sort of wash over you is what I always suggest, keeping in mind that you can come back and watch the recording of this webinar, look through the slides and some of the other materials we're making available at a subsequent date. So don't feel like you have to try to learn all of this at once. As I mentioned earlier, I've been sort of soaking in it for 13 years, and that's given me a lot of time to try to wrap my brain around all the little different pieces. But it is a lot to take in all at once. So let's start with the road to financial value transparency. How did we get to where we are today? So since 1965, the Higher Education Act, which is, of course, the key authorizing statutory language in the law for the Title IV programs, since 1965, the HEA has required all non-degree programs offered by public and private nonprofit institutions and all programs offered by proprietary institutions to, quote, prepare students for gainful employment in a recognized occupation. And I just want to highlight here that this language is in the statute and then it's repeated in the regulation. This is a key concept to understand today. If you don't get your brain wrapped around this, the rest of the presentation is gonna be difficult to process, right? So this is really an important foundational point, right? So gainful employment programs are those programs that in the statute and regulatory language, it literally says these programs have to prepare students for gainful employment. And then there are other kinds of programs that can be eligible Title IV programs that are non-GE or non-gainful employment programs. And this language doesn't appear in the definition of those programs. And that's how all of this is built. It's all built around these definitions of eligible programs. So just trying to simplify things a little bit, right? You see, if we put a chart here together for you, and it shows the type of institution, and then for those institutions, what's a gainful employment program, what's a non-gainful employment program. So let's start with public and private nonprofit institutions. All of your non-degree programs, meaning like your certificate programs, your diplomas, and that could be undergraduate or graduate. So if you've got a graduate certificate program and you're a public and private nonprofit institution, that's a gainful employment program, not because it's graduate or undergraduate. The distinction is degree or non-degree. So any non-degree program that you offer at a public or private nonprofit institution is a gainful employment program. Everything else we'll call a non-GE or non-gainful employment program. And that's basically all your degree programs. By the way, this nomenclature, GE programs and non-GE programs, is used throughout this new rule. So it is worth keeping those sort of particular labels in mind. If you're a proprietary institution, as defined under the Higher Education Act, all your programs are GE programs. So it's pretty simple. And sometimes you'll hear folks talk about how historically, the gainful employment rule has a disproportionate impact on proprietary institutions. And in its prior incarnations, and to some extent even in this incarnation, that's true. And that's not because the rule that was created by the department is somehow designed, or they somehow say, well, this only applies to proprietary schools. It's because proprietary schools have more gainful employment programs, because all of their schools under the statute are GE programs, right? So there is a disproportional impact, but it really has to do with how the statutory language is designed. At any rate, for our purposes today, the most important thing is that you just keep in mind, if you're a private, nonprofit, or public institution, when I say GE program, I'm talking about your non-degree programs. When I say non-GE program, I'm talking about your degree programs. And for proprietary schools, everything's a GE program. All right, so in 2010, the Obama administration created the first version of the gainful employment rule. And really, the idea here was they were trying to create a rule that sort of measured whether or not gainful employment programs satisfied this standard, meaning that the program was preparing people, right, for gainful employment in a recognized occupation. So they created what I think it's fair to say was a very complex rule that, among other things, and this was the real key core part of it, attempted to compare the typical debt a program's graduates took on with their typical earnings. So you'd take a cohort or group of students who completed at a particular point in time, and you would look at how much debt they took on to complete the program, and then you would compare that with their earnings at some point 2 or 3 years after they graduated. Now, what's interesting is in this very first incarnation of the rule, rather than trying to look at actual earnings of graduates, they were looking at BLS data. But the concept was still, we're going to compare debt to earnings information for a particular cohort or group of students who completed during a particular point or period of time. There was also a repayment rate concept that was built into that very first version of the rule. Critically, if a program's debt to earnings rate, or in that first version, repayment rate, did not consistently satisfy standards established by the department, then the program could lose eligibility for Title IV. So the stakes are high, particularly if you're an institution with only 1 or 2 programs. So since that point in time, there's been quite a history with the GE rule. And this is important because as you're thinking about what's going to happen next with the current version of this rule, I think it's important to appreciate that the past could be prelude, right, a little bit in this case. So the 2010 GE rule was largely vacated by the U.S. District Court in D.C., which found that repayment rate threshold actually was not sufficiently justified by the U.S. Department of Education. And because of the way the rule had been designed, when they invalidated the repayment rate concept, it more or less invalidated most of the functioning parts of the rule. So the Obama administration came back around in 2014 and published a second version of the rule. And once again, they were sued. And once again, the U.S. District Court in D.C. had found that the department acted, quote, arbitrarily and capriciously with respect to sort of the overall methodology. And the court was particularly concerned about, in this case, this version of the rule, its use of actual earnings and the fact that the rule did not seem to accommodate for underreported earnings and similar type wage discrimination concerns along those lines. And in fact, the court had already granted a plaintiff's motion for summary judgment. But before that litigation could play out in its fully, the Trump administration rescinded the 2014 rule. So that's where we are right now. I should have said that's where we were. Well, that is where we are right now in the sense that there's not today another rule on the books, right? Now the Biden administration has come along, and they indicated in 2021, 2022, they wanted to recreate this gainful employment rule, and they went through a negotiated rulemaking, which of course is required if you're talking about Title IV regulations. And in May of this year, May of 2023, the administration published its new proposed financial value transparency and gainful employment rule. I take you through this history just to highlight that every version of this regulation has been taken to court. And as we'll talk about later today, we fully anticipate that this version will be as well. And candidly, its track record is not great. The first time it was struck down in large part. The second time, the court seemed to be leaning in that direction before it was rescinded by a subsequent administration. And I think it's fair to say by the Biden administration's own characterization that this is the most aggressive, I think they would use the word strongest, it depends sort of on your point of view, but it is definitely, however you want to characterize it, the strongest or most aggressive version of this rule to date, which probably means that there will be even more fodder for folks who are looking to challenge the rule. So on October 10th, today, like I said, this initial broadcast is November 7th, so October 10th, not quite a month ago, the U.S. Department of Education published its final financial value transparency and gainful employment rule. And if you're looking at the actual PDF slides after the fact, you can click on that link or you can click on the picture of the Federal Register and it'll take you to the final rule. So this rule is set to take effect next July 1. So that's July 1 of 2024, which is, as you know, if you follow Title IV regulations, if you get it in by November 1 of any year, then it can become effective by July 1 of the subsequent year. So right now, we anticipate this rule has hit the Federal Register in final form and that it will become effective July 1 of next year, July 1 of 2024. But there's some really important, right out of the gates, and I wanted to highlight this early in the presentation, differences to appreciate about this rule, particularly if you are a private nonprofit or public institution. So the department in this version of the rule for the first time is going to calculate and disclose a debt-to-earnings rates. There's actually two debt-to-earnings rates that it calculates for each program each year. So it's going to calculate and disclose both of those debt-to-earnings rate and a new earnings premium metric for every Title IV program at every Title IV institution in the United States. So to be clear, all the GE programs and all the non-GE programs. So I will just say this again because sometimes people sort of look at me like I'm not speaking sensibly when I explain this. So if you are a large public university and you have hundreds of programs, what we're talking about is the department is going to calculate a debt to earnings and earnings premium metric for every one of your programs, right, that you offer if it's a Title IV program. So, and that's of course not just public flagships, any large school, even if you have hundreds of programs, it's for every single program. These metrics, along with other data, will be made available to prospective and current students through a new website that the department's going to create that it's calling its program information website. And the department, based on the program's performance, in other words, whether its DE rates and earnings premium satisfy the metrics that the agency has established, it's going to label on its website whether it thinks that program is, quote, low earning or high debt burden. And a lot of people challenged this when this was proposed in the proposed rule, and the department came back in a final rule and said, look, we think this is important. We think this is clear and simple language, so we're going to stick to our guns here. And at present, it's anticipated that they're still going to do this. So once again, just to be clear, the Department of Education is going to build a website. It's going to calculate numbers relating to debt and earnings and this earnings premium for every single Title IV program at every single Title IV institution. It's going to put all of that on a public website. And if the programs don't satisfy these metrics, it may label your program as low earning or high debt burden. So right now, if you're a compliance officer or legal counsel or financial aid, you may be saying to yourself, I should probably get with my vice president of enrollment and make sure that they know about this, right? And I think that is true. I think, and we're going to talk about at the very end of the presentation some action items, but I absolutely believe it's critical right now that institutions, you need to decide who's going to own this rule, and it's probably going to require input and participation from folks in various different verticals within your institution. And certainly I would think academics and admissions and enrollment are going to be very interested because program design is going to impact performance. You know, cost is going to impact performance under these debt to earnings rates. And then whether or not you can enroll folks successfully in a program on a go-forward basis may be impacted by whether or not the Department of Education is publicly on its external website indicating that that program is low earning or high debt burden. So you're starting to appreciate why this is a really impactful rule. It still will be the case that only GE programs can lose Title IV eligibility if they underperform over 2 years in a row or 2 out of any 3 consecutive years. And we'll get into the metrics and the timetables later. But I want to point out that all these non-degree programs are still GE programs, and consistent with prior versions of this rule, if they are not performing up to the standards established by the department, they could actually totally lose eligibility, right? But the new rule also includes significant reporting and disclosure requirements for all institutions, and failing graduate level non-degree programs also can be sanctioned. So let me just say that again. At any private, nonprofit, or public institution, if you have a graduate degree program that's a non-GE program, because you're a private, nonprofit, or public institution, and this is a graduate degree program, it is by definition non-GE, it can still be subject to sanctions. Not a loss of Title IV eligibility, but unfavorable sanctions. And I'm going to talk about that later too. So in connection with both the proposed and the final rules, the department used a data set that it referred to as the 2022 Program Performance Data, or the 2022 PPD. And if you go back to, actually, if you go to regulations.gov and visit that website and put in the correct number for this rulemaking, right, which you'll see we can include, or if you can't find it, give me a holler. It's right there. If you go to the Federal Register for the proposed and final rule, you'll see the number that goes along with the rulemaking. Sometimes there are additional documents that are released in connection with the rulemaking, and you can find those on regulations.gov, or I think they're on the Federal Register website as well. If you go there, you'll see there's a giant spreadsheet that includes all of this data for all of these institutions and programs, right? So metrics were projected as part of the proposed and final rule. They projected how institutions and all their programs would perform under these two new standards, the debt to earnings rate and the earnings premium. So metrics were projected for Title IV programs that were active in 2022. And the debt and cost figures that they used were calculated using NSLDS data for students who completed their programs in award years 15-16 and 16-17, right? The earnings figures, right, so that's the denominator of this debt to earnings calculation, were calculated using data obtained from Treasury for students who completed in award years 14-15 and 15-16, using their earnings from calendar years 2018 and 2019. Now, just a couple of quick things to point out, right? This is probably the most complete and most recent data set that you can look to right now if you just want to see how you think your program might perform without doing any of your own projections. Keep in mind, it is not constructed in the same way that the new rule is constructed. So in other words, the process they use to gather data and calculate and project these rates is not exactly the same process that they're going to use when they actually gather data and calculate debt to earnings and earnings premium metrics for all programs at all institutions on a go-forward basis. But it's close, and it probably gives you a sense of what the impact might be, right, for a particular program or for your institution in general. So you can go, this is a publicly available data set. If you can't find it, let me know. I'm happy to email it to you. The other thing I'll just point out that maybe caught your eye right away is the debt and cost figures are from students who graduated in one set of award years, 15, 16, 16, 17, and the earnings figures are from students who graduated in slightly different timeframes. So we're not even comparing debt and cost and earnings from the same groups of students. But again, this is still probably the best publicly available data set right now outside of trying to project your own rates. And this is why I got to this, because again, I think it's hard for folks to maybe conceptualize the breadth of the impact here, and I wanted to highlight what the data shows. So the department projects, let's start with non-GE programs. So this is the projected impact, right, on degree programs offered by private, nonprofit, and public institutions. Proprietary schools aren't on this slide because all of their programs are GE programs, right? So the department projects over 820,000 students are in nearly 1,500 failing non-GE programs. They indicate about 842 programs at public institutions serving about 555,000 students, and 640 private nonprofit degree programs serving about 264,000 students would fail at least one of these two metrics. So all of these programs, theoretically, if the department had its new website, would be labeled as high debt burden or low earning, depending on which of those metrics they failed or if they failed both. The department, this is a quote out of the final rule, rates of not passing at least one of the metrics are particularly high for professional programs in law, about 19% of law programs, representing 29% of enrollment in law programs. So what the department is saying, just to be clear, is that nearly a third of students right now are in law programs that would fail one or both of these metrics. That's a fairly extraordinary statistic, I think. Theology, you're talking about 25% of students are enrolled in theology programs that would fail. And health may be surprising to some. About 19% of students are enrolled in programs that would fail, representing about 10% of programs overall. The department projects 390 graduate level non-GE programs under this data set would fail and be subject to sanctions. So that's there are about 122,000 students right now that are in programs that would be failing and be subject to sanctions under this new rule. Again, fairly extraordinary. Now, and this is an incredibly important point here at the end too. The department excluded 82.7% of non-GE programs from this data set because they had fewer than 30 students in the 2-year completer cohorts. What do you mean by that, Aaron? So when the department, again, we'll get into these calculations in a bit, but when the department calculates these numbers for privacy reasons, when they go back and say, okay, we're going to start by looking at the students who graduated from your program across 2 award years. But if you don't have at least 30 students who graduated across those 2 award years, then what the department does is, under the new rule, they expand that cohort to 4 award years. And if you have at least 30 people who completed the program over 4 award years, they'll calculate the number for you, and you'll get a DE rate and an earnings premium. But when they did this particular data set, if you didn't have at least 30 in the 2 years, they just didn't calculate the number. But what that means is when you look at these numbers, how many actual programs failed, how many actual students were in those failing programs, think about all those programs that didn't have at least 30 graduates in the 2-year award timeframe, the 2-year cohort, right? They were excluded. They weren't even included in this data set. But if they had at least 30 across 4 years, they would be included under the new rule. All of this is to say, these numbers are probably low, right? Because when the department actually runs its debt to earnings and earnings premium calculations in the future, it's going to run the numbers for any program that had at least 30 completers across 4 award years. That's going to capture more programs and more students. The impact on gainful employment programs, as you would expect, is also significant. And keep in mind, all the private, nonprofit, and public institutions have far fewer programs generally in this bucket. Proprietary institutions, all their programs and all their students are in this bucket. So the department projects nearly 700,000 students in a little over 1,700 failing GE programs. They indicate 193 public GE programs would fail, about 73 private nonprofits fail at least one of the 2 tests. Of the 1,440 proprietary GE programs that would fail at least one of the 2 tests. Oh, that's sorry, I skipped over that. So in the first bullet, and for proprietary institutions, about 1,440 proprietary GE programs serving 620,000 students would fail at least one of these 2 DE tests. Okay, so of these 1,440 GE programs that fail one of the 2 tests, 939, 2/3, are undergraduate certificate programs that fail only the earnings premium. So this is the first version of this rule that includes the earnings premium. It's a new concept, one I'm confident will be litigated, right? And the point of this statistic is it highlights the extent to which a significant percentage of the programs that are failing wouldn't fail under the traditional debt to earnings rate that's been in the prior 2 versions of the rule as well. They're only failing under this new earnings premium, and it's primarily certificate programs. So we're talking about short programs that would cost less, but typically also that produce graduates who earn less. And that becomes a problem under the new earnings premium, which we'll talk about, as I keep saying, later in the presentation. The highest rate of failure is in personal and culinary services, where about 73% of enrolling students are in programs that would have failing metrics, mainly again under this earnings premium. So the second time the Obama administration created a rule that was in 2014, a gainful employment rule, it was the American Association of Cosmetology Schools that brought that lawsuit. I think they are a prime candidate for being the lead plaintiff in a lawsuit this time around. And you can see why. Because for this membership, and for those of you who may be watching, as I'm sure you know, if you work or own a cosmetology school, or if you're a public institution that has a cosmetology program, this rule is tough on cosmetology programs, really tough on cosmetology programs. Here again, as with the prior slide, I'll note that the department excluded 87.7% of GE programs from the data set. Fairly remarkable because they had fewer than 30 students in the 2-year completer cohort. So again, my expectation is these numbers actually are understated when you talk about, the actual number of programs and actual number of students impacted, because as the department runs the real numbers and captures more programs based on using that 4-year cohort, presumably some percentage of those programs are going to fail, and you're going to see these actual numbers go up. Let's talk about roadblocks. I've hinted at this already. So there are a number of things, to be clear, that could get in the way of this rule. I do not think, and as I'll discuss in action items at the end, that institutions can bet the farm on the idea that one of these roadblocks will become successful and the rule won't become effective. But there is no doubt that it's a rocky road between now and sort of full and ongoing implementation. First of all, the results of the 2024 presidential election will almost certainly impact the rule's viability. The prior Republican administration made very clear, that department, that they did not believe that this rule was ready for the light of day. That's not to say that that administration was not interested in accountability metrics. Despite, I think, what is sometimes common belief, the Trump administration revised many rules, but it didn't rescind entirely that many. Think about financial responsibility reporting. Think about bar defense. They were retooled, but they didn't throw them out entirely. Gainful employment is one that was thrown out entirely because the administration didn't feel like it had a workable model yet. And as you look at the public comments that were filed in response to this rule, you look at the prior lawsuits, it is a complicated rule, and it's hard to implement it in a way that doesn't seem to have a lot of problems, at least from my standpoint. So I think a Republican administration would likely come in, take the view that the prior Republican administration did, which is, it's not that we're anti-accountable, but we think this thing's got a lot of problems, so we're going to take it off the books. They would have to do that through rulemaking, for certain, but the expectation is eventually that they probably would. We strongly anticipate that the rule will be challenged in court like the prior versions. But a key point is whether or not it would be enjoined. What I mean by that. So keep in mind, a party could sue the department over this regulation, and the court could say, we're willing to entertain the lawsuit, but we don't think the stakes are so high that we're going to enjoin its implementation. So the rule and its implementation can go forward until the lawsuit runs its course. In which case, you could be 1 or 2 years into the gainful employment rule cycle before the court rendered a decision. We all know litigation can go for months and months. So a really important idea will be whether or not we would expect this lawsuit to be filed prior to the effective date of July 1, 2024, and we would expect a plaintiff to ask the court to enjoin the rule so that it never goes into effect while the litigation is pending. In other words, enjoining the department from implementing the rule. That'll be a very important decision, and that's something that folks will want to keep an eye on, particularly as we talk about the reporting requirements that are due in July and October of 2024 if this rule is in fact implemented and moves forward. So that injunction could impact whether you're actually reporting all the data or not. The department also candidly may struggle to timely implement the rule given resource constraints. Those of you who interact with the department on a daily basis, I've said many times, I will say again, my impression is that the staff at the department are working very, very hard right now to handle all the wide range of tasks that they have to handle every day. But there seems to be little doubt that since the Obama administration, there has been a reduction in hands on deck over at FSA due to a lot of different things. And the department also has not gotten approval of the appropriations that it's put in recently under the president's budget. So as a consequence, they seem tight on cash, so to speak, and our resources at any rate. And this rule would take an enormous amount of effort and human and technological and capital resources to sort of move forward, right? I call it turning the crank. In other words, to calculate rules for a given year and to get through the whole process and move all this data. I mean, keep in mind, and you'll see this when we talk about the reporting requirements, institutions are going to be reporting an enormous amount of data to the U.S. Department of Education. I mean, you're reporting data to the department for multiple award years for every program and every student in every program. There's 6,000 institutions of higher education in the United States. There are hundreds of thousands of programs, and there are millions of students. that's a pretty significant infrastructure that's going to have to be erected in order for the department to take in all that data, crunch all the numbers, and do what it needs to do. I've no doubt it's already working on it, but it's also working on Title IX, and it's also working on all these other rules and bar defense claims, et cetera. So I think there's a real question as to what kind of resources are going to be available for them to turn the crank, as I say, on the gainful employment rule, the trademark pending. So let's talk about the new regulatory framework. That's the prelude stuff. Let's really start to get into this thing, into the nuts and bolts. And maybe this section is primarily for the lawyers and compliance officers on the line. But to someone who does what I do for a living, it's interesting. So to accommodate this new and expanded rule, right? And in particular, I mean the expansion of the rule to cover all of higher education and not just gainful employment programs. The department has actually reorganized the approach that it's taking in the regulations themselves. And I just wanted to highlight this for you for a second. So provisions that apply to all Title IV programs, reporting, disclosure requirements, how the numbers are going to be calculated, all of that stuff are in a new Subpart Q, and that's the section that's titled Financial Value Transparency. Separately, the department has created a new Subpart S that's titled Gainful Employment, which contains the provisions specific to gainful employment. What's interesting is because most of this new rule applies to most of higher education, most of the regulation is in Subpart Q. Now, I do want to highlight just really quickly, you'll see 668.43, which is the consumer information part of the regulations that includes like your Clery Act and all your institutional programmatic information, all that data you have to produce every year, the reports you have to issue and disclose, right? That's where the department has tucked in the new rules relating to reporting of data that it's going to need to process and create all of these rates in its website. Also, that's where it includes the new information about its website. So the reporting stuff and the stuff about the new program information website are in 668.43, or will be come July 1, 2024. Subpart Q, again, is all the stuff that applies to every institution. So that's sort of the basics around the whole debt to earnings and metrics and how they're going to be calculated and what you have to do if you're a nonprofit or public and you got a graduate degree program that's failing, that kind of stuff. And then it's actually a relatively small amount of regulation now that appears in Subpart S, or will appear, and that's the gainful employment information, right? So all the stuff about calculating and metrics, et cetera, just applies to everybody. So it's not now in the Subpart Q. And combined, this is sort of visually, you can see where all these things are located, and this is most of the new regulation and its infrastructure. A couple of noteworthy institutional exceptions that surfaced in the final rule. So first of all, the department indicates due to data quality concerns, the department is exempting institutions located in the territories or freely associated states from most of the requirements in the transparency framework under Subpart Q and from the GE accountability provisions under Subpart S. So in other words, if you are in Puerto Rico or the Marshall Islands, if you're in a territory or freely associated state, you are largely exempted as an institution. I don't mean program by program. I mean your institution, it's all of its programs are largely exempted from this whole new framework. However, keep in mind, you will still be required to comply with the reporting requirements under 668.43, and the department does anticipate still trying to calculate median debt and median earnings information for your programs. So, to be very clear, while most of the framework doesn't apply to you, the reporting obligations we're going to talk about are still going to apply. And it sounds to me like the department still intends to include you on their program information website and potentially to put some information out there about median debt and median earnings. There's also a general exemption from both Subpart Q and Subpart S, so financial value transparency, gainful employment, for institutions if, and this is sort of an odd phrase I'm going to throw at you, and I'll try to explain it, if over the most recently completed 4 award years, the institution offered no groups of substantially similar programs with 30 or more completers. So a substantially similar program is as defined in these new regulations and has sort of as a policy matter been deemed by the department in the past is programs in the same 4-digit zip code. So if you are a financial aid professional or in other verticals at your institution, you may know every program that you offer has a 6-digit zip code. That's a classification of instructional programs code, and that's a federal taxonomic scheme for sort of slotting all the different programs, and it ties into SOC codes and certain occupations, et cetera. But every program has a 6-digit zip code. The first four digits, sort of as you get more further out from 2 to 6, you get more specific. So 6 is fairly specific. You would expect programs that are very, very similar, law programs, medical programs, to have a 6-digit zip code. If you reduce it down to a 4-digit zip code, then you're sort of expanding, and you might be collecting programs that aren't identical but are fairly similar to one another. And then the 2-digit zip would capture a whole lot of programs that are different but related, right? So what the department is saying is, if you look across the zip codes on all your programs, let's say you've got 5 programs that you offer, right? And 3 of them have the same 4-digit zip at the root. Then the department's saying those are substantially similar. So when we're looking at this, what they're saying is, if you haven't had 30 or more completers, not just in any individual program, but over the last 4 years, if you haven't had at least 30 or more completers, and those 3 combined that have the same 4-digit zip, or in any of your other substantially similar program groups, then your whole institution is exempt from having to participate. And the department indicates, I think it may be on the next slide or elsewhere, that about 700 institutions may qualify for this exemption. So that's not bad. 6,000 institutions of higher education, it's about 10% maybe taken off the boards. And what we're talking about, are institutions either where the institution's very small or just its programs are very small in the sense that they have very few students graduating from those programs. Again, less than 30 across your all substantially similar program groups over the last 4 award years. So these are pretty small schools, right? All right, now we get to our very first secret word. Here it is. So don't forget, at this point during the presentation, there should be a child box popping up off either to my left or my right. I'm not sure where it's going to be on the screen. And it's going to give you 3 or 4 different words, right? One of those words should be it's, like the contraction for it is, it's. And I want to make sure you get credit for your continuing legal education. So please find that child box. Find those words with the little radio buttons next to each one and click the radio button next to the word it's. It's. I-T apostrophe S. All right. So hopefully that has been enough time for you to find that magical box and click that magical button. I want to get back into the presentation. So one last time, click the button next to the word it's. Okay. Moving right along. So now the next sort of segment of the webinar, I want to get into the metrics themselves. There are 2, I've mentioned several times. There's the DE rates and the earnings premium. Now I'm going to get, you hear people talk about flying at 40,000 feet or explaining something. We're going to do this at about 20,000 feet, right? So I'm going to give you enough detail, hopefully, to understand what these metrics and calculations are really about. But the next webinar we do in this series, right? I mentioned earlier, about 7 days from now, we expect next week we're going to be hosting a webinar that's specifically about projecting these DE rates and the earnings premium, right? And that's the webinar where we're really going to get granular and go through all the very specific aspects of these calculations, right? But today, my goal as part of this general overview is to give you enough that you understand what these rates are about. And even that you may find is a lot of detail. Okay, so with limited exceptions, like the 2 we just talked about, right? With limited exceptions, each year the department will calculate 2 debt to earnings rates, or DE rates, for all Title IV eligible programs at all Title IV eligible institutions. Here they are. One is your annual debt to earnings rate. The other is your discretionary debt to earnings rate. And I want to point something out to you. Note that the numerator in both of these is the same, your annual loan payment. So they're going to calculate these 2 rates for each program that you offer. This isn't an institutional level calculations. For each program, you're going to get an annual DE rate and a discretionary DE rate. The numerator for both calculations is the same. And in fact, the denominator is pretty similar. What the discretionary earnings really represents, and I'll show you a slide in a minute that spells this out, but they take that median annual earnings and they subtract from it the earnings for a single person, the poverty line earnings for a single person. And that's to sort of, the discretionary DE rate is really designed to benefit very expensive programs that also produce graduates who make a lot of money. So think like medical graduate medical programs or potentially law programs, something along those lines, where you take on a lot of debt to get through the program, but you hopefully are making enough after the fact that you can service your loans and stay above the poverty line. And so that's the whole reason that sort of alternate rate was created, was to benefit those really expensive programs. And the idea is to show that, yes, these students have a lot of debt, but they're making enough that they're able to service that debt again and stay above the poverty line. Okay, so to calculate, let's focus on the numerator first in each of these equations, right? The annual loan payment. To calculate the annual loan payment for each Title IV program, the department's going to begin by identifying the completers list for the program. In other words, who the graduates we're concerned with, right? We got to come up with a list of names. And that list of names, the completers list, which we'll talk about later and here in the department, this is an official phrase that they use, the completers list. I mentioned earlier, it's comprised either of a 2-year cohort of students or a 4-year cohort of students. And I'll use this phrase of qualifying completers, right? And I mentioned previously, the department always starts with 2 years. But if you don't have at least 30 completers in that 2-year time frame, they don't want to calculate rates on cohorts with less than 30 students, because the concern is a privacy concern for those individual students. So they want to make sure they've got at least 30. So if they can't do it in 2 years, they'll expand the cohort and they'll say, okay, we're going to put everybody who graduated across 4 award years on our completer list. And then we're going to look at the debt and cost and earnings information for all of those folks who graduated in that 4-year cohort. So you always start with the 2-year cohort. And if you don't have enough people, then the department will expand and look at the 4-year cohort, right, in trying to get to that numerator. So qualifying completers, by the way, what do I mean by that? And this is really important too. So when we're doing all of this, when the department's crunching these numbers, it's only looking at students who completed the program. Now they're going to they want from you data. We'll see this in the reporting section about folks who withdrew. And they may at some point start working on, withdrawal rates and things of that along those lines. But for purposes of the debt to earnings calculation, the department's just looking at completers, right? And more specifically, completers who receive some form of Title IV aid and who do not otherwise fall into an excluded category. And there's a list of students who are excluded. And I give you as an example here, someone who is deceased, right? So the department is not going to penalize you if a deceased student is not earning what we anticipated they might earn once they took a job. Very, very, very thoughtful. Also, a note on the Title IV aid. This doesn't mean they have to have loans. It just means they have to have any kind of Title IV aid. So theoretically, you could have a student on your completer list who completed the program during the appropriate 2 or 4-year cohort period, right, who's not otherwise excluded and only got a Pell Grant and had no loans, which would be great for you, by the way, because that means they had no debt to go into that numerator, right, but you're still getting the benefit of their earnings potentially. In the commentary to the proposed rule, the department indicates that given current data production schedules, the initial DE rates and earnings premium would be calculated in late 2024 or early in 2025. Right? Now, my bet is late 2024 is going to be a real push because they're not even going to get all the data they need ostensibly until October 1st. But I think the department is going to try very hard to make sure that it turns the crank, right? Gets all of this done in the 24-25 award year because they don't want to get so far behind that they're running concurrent cycles, right? They want to get through everything before the next cycle starts in 25-26. So my expectation is the first half of 2025. This is important because when we're trying to figure out the years for which data is going to be collected and all of those types of things, we need to start by understanding the first time frame in which they'll be calculating rates. And fortunately for us, and I want to make this very clear, the department details all of this in the Federal Register, both in the proposed rule and then they reinforce some of it in the final rule. So to be very clear, these timeframes that I'm showing you throughout this presentation are not speculation on my part. They're actually built on examples that the department included in the Federal Register. This is also a good point to just note that at the bottom of your screen, when we are quoting something from the Federal Register or the regulation, we tried to give you citations throughout. So if you are a lawyer or compliance type and you want to go look these things up, hopefully the citations will help you get there. So again, the department said in the proposed rule, look, we expect that we're going to try to get all this done and to produce this first round of calculations in 24-25. They'll be getting all the data in the second half of 24, so our bet is early 25. But this is the other really important stuff that they get into. For most programs, the 2-year cohort period would be comprised of qualified completers who completed in award years 17-18 and 18-19, using earnings data measured in calendar years 21 and 2022 as applicable. So this would be under the standard calculations. And I'm going to show you there's a transitional calculation concept that we'll talk about a little bit later. So this is under the standard calculation concept. But the really important point is, I think if I'm a school, one of the things I'm asking myself is, well, when they start crunching these numbers, who are the students they're looking at so that I can try to go project these rates? Well, this is what we're telling you now. So we're talking about folks who graduated in 17-18 and 18-19 and what they earned in 2021 and 2022. And as you would expect, it sort of tracks. So we're looking at 2021 earnings for folks who graduated in 17-18 and 2022 earnings for folks who graduated in 18-19. The department confirms these projections in the final rule, observing, quote, the first official rates published under these regulations will, for most programs, be based on students who completed a program in award years 18 and 19, measuring their earnings outcome in 21 and 22. And when the department again refers to award years 18, 19 here, they're talking about 17, 18, and 18, 19. Okay. One side note. So we said for most programs there, we had a couple of points where we sort of carved out for most programs. So the final rule includes a new definition, a new concept of qualifying graduate program. And this has one meaning in the first 3 years after the rule becomes effective and another afterward. But fundamentally what we're talking about here is programs with students who must complete required post-graduation training programs to obtain licensure in fields like medicine, osteopathy, dentistry, clinical psychology, et cetera. And the department, what's going to change over time is the department's going to kind of look at who all ought to be included, and they're going to put something out in the Federal Register at some point where they're going to specify which programs. But conceptually, the notion here is students who graduate from these programs have these required clinical components, and so they're not actually earning anything, even not even talking about lifetime earnings or anything like that, but even comparable to what they would be earning after their clinical. Their wages are extremely depressed during these clinical experiences. And so the department's sort of acknowledging, okay, it wouldn't be fair then for almost all other programs, except for these qualifying graduate programs, the earnings are measured about 2.5 to 3 years after the student graduates. But what the department is saying is, for these programs, we recognize we need a more distance there. We need to give them enough time to graduate, get through their clinical where their earnings are depressed, and then get to a point where they're at least earning something comparable to, beginning of career earnings. And so in order to do that, what the department's going to have to do is it actually has to ask for older data so that it can start crunching the numbers in 24, 25, right? So in other words, the department isn't just going to delay implementation of the rule for these programs. Instead, what it's going to do is it's going to say, we're just going to look at older cohorts so we can create more distance between them and the earnings year that we're going to be using. So for qualifying graduate programs only, the 2-year cohort period will be award years 14, 15, and 15, 16. And the 4-year cohort period would be award years 12, 13 through 15, 16. So you may be asking yourself, and let me just confirm for you, yes, what the department is contemplating is that in the first year and we'll talk about this later, by the reporting deadline, which is July 31st of 2024, that you will be, for any qualifying graduate programs, providing the department data from 12-13, a decade ago. Right. And some of you may not have it, and there's a way of dealing with that as well. But you can see all the data gathering that occurs with this rule is from years that precede July 1st, the effective date. This is a visual to sort of help you understand and think through, because I know it's really weird the way the department says, well, it's going to be, the 2 years and the 4-year cohort, et cetera. We find that it helps to sort of have it all laid out graphically. So for the first year, the department would calculate rates, remember, 24, 25. What they're telling us is, for your standard program, the standard 2-year cohort rate, you're talking about students who graduated in 17-18 and 18-19. I'm pointing at my screen because I'm looking at this too, right? The 4-year cohort would be 15-16 through 18-19, right? So we're talking about students who completed in those award years. Now, if you've got a qualifying graduate program, the 2-year cohort we'd start with is 14, 15, 15, 16, and then that 4-year cohort is 12, 13, all the way through 15, 16. So hopefully that gives you a sense. When we're talking about where is this numerator coming from? Where's all this debt and cost information coming from? The starting point is to understand your cohorts. So we're talking about, Title IV students who aren't otherwise excluded and completed during these award years. And if you've got fewer than 30 in the 2, they expand it to the 4. Okay. So now let's talk about what will they do with that once we have the completers list. So for each student, and I find this another visually helpful way to sort of think through this. Also, as a practical matter, when we're projecting numbers, this is more or less what the spreadsheet starts to look like. So you see in the first column on the spreadsheet, this is your completer list. So we've done all the stuff we just talked about, and we came up with your list of students that completed the program, who are qualifying graduates who completed the program during the 2 or 4 year cohort. And they're on the first line. So then what we're going to do is for each of those students, using some specific parameters in the regulations, we'll talk about this in the webinar next week. This is where we'll really get into the details. We're going to calculate a debt number. How much debt did each one of those students take on to complete the program? Then we're going to calculate a net direct cost number. So how much did we charge them? Less any institutional aid, basically. And then for each student in the program cohort, our last column is going to be the lesser of those two numbers. So did they have less debt, or did they have less net direct costs? And what the department's trying to do here is to some extent give institutions the benefit. If you got students who are borrowing more than the cost of the program, then the department's going to sort of cap things at the cost number. In other words, they say we're not going to hit you in the numerator for more than you actually charge the student. But keep in mind, if you're charging your student, and you'll see this as an example, look at student number 2, about halfway down. We charged them $80,000. They only took out $5,000 of debt. Maybe they had cash on hand. Maybe Uncle Ed helped them pay for their program. Who knows? But in this case, the department's going with $5,000 because that's the lesser of the two numbers. So you get the benefit. And when you start thinking about program performance and projecting rates, again, we'll talk about all this in detail next week. One of the things you want to be smart about is to understand in a given program, are my students typically borrowing less than what the program costs, or are they typically borrowing more? Because that will inform your strategy for that program regarding how you may want to improve your rates. And this is really, really important to understand. Theoretically, if you had a program that you're charging students $10,000 and everyone borrows $5,000 and you reduce your tuition to $9,000, you are not improving your DE rate because the students, it's the $5,000 debt number that the department's taking, right? I mean, you might say, well, maybe they'll borrow a little less if I knock $1,000 off the cost of the program. Unlikely, right? So you want to be thoughtful about how you're approaching, and keep in mind, it changes from one program to the next. So you can't just use a blanket strategy across all your programs. You need to be thoughtful about how each program, what the borrowing and cost profiles are, and you have to develop a strategy, particularly if you got a problem program, for improving that program that's specific to the debt and cost profile for that program and earnings profile, right? Okay, but getting back to the point here at hand, so what the department does is they've got the completers list, right? And they're going to figure out the debt number, they're going to figure out the net direct cost number, they're going to take the lesser of the two, they're going to line them all up, and then they're going to take the median. Not the average, the median. So in the little graphic I've got here for you on the screen, you can see student 13 just happens to be the median for this program group. Now, I know there's fewer than 30 completers here, so theoretically, if this were an actual example, the department wouldn't calculate DE rates. Let's just pretend that there are 40 people on this list for the 2-year cohort, okay? But the point is the median here in this example is $25,000. So that's the median loan debt, right, for this program, for this cohort. Okay, so then what do we do with the median loan debt? The department's going to amortize that median loan debt over the applicable repayment period using a prescribed interest rate. So if you look in the regulations, it says depending on the length of the program, the repayment period changes. And then there's a formula for figuring out which interest rate applies. And it's based on the historical interest rates for direct loans for undergraduate and graduate, respectively. Again, we'll go through all of this in next week's webinar. Okay, but the point is the department takes that median debt number for your cohort and then they amortize that number. That's how they get your numerator. And that's the numerator for both debt to earnings rates. Remember, it's the annual loan payment for both of those rates. Okay, what about the denominator? Where do these earnings come from? So the department's going to calculate the median annual earnings. They're really not going to calculate the median annual earnings. What they're actually going to do is they're going to put that completers list together of all your completers, and they're going to send it to an unidentified earnings agency. It was the Social Security Administration during 2014, the prior version of the rule, the department in the I think it was the preamble to the proposed rule that we're dealing with now that just became final, indicated its preference is the IRS. So we'll see. It sounds like it's going to be the IRS. So they'll send that list of completers to the IRS, and they'll say, hey, send us back not all the earnings, so the department's not supposed to get any individualized data. Instead, what the IRS or the earnings agency is supposed to do is they're supposed to take that entire list and they're supposed to identify the median earnings number and then send that back. So what's going to happen is the department's going to figure out the median annual earnings by effectively sending the completers list to the earnings agency. And then that becomes the denominator for the annual DE rate calculation. And I mentioned earlier, the discretionary earnings is just a slight variation. So what they'll do is they'll calculate discretionary earnings by subtracting from that median annual earnings number the poverty guideline for an individual in the United States put out by Health and Human Services multiplied by 1.5. So you've got that median annual earnings minus, imagine sort of your parens, the poverty guideline times 1.5. And that becomes the denominator for the discretionary DE rate calculation. But the key idea here is, one of the key ideas among many, is that the department is trying to take actual cost data, actual debt data, and actual earnings data to run these numbers. None of this is based sort of on BLS averages, Bureau of Labor Statistics averages, or anything along those lines. So this graphic is supposed to help you, it helps us for certain, visualize the relationships among these various concepts. So if you look in 2024, 2025, it's the very first column, right? You see the standard 2-year cohort. If you go down, I've got the award year of completion that's going to be used for costs and debt, and then the calendar year used for earnings. So if you scooch down in the 2024, 2025 column, you'll see the standard 2-year cohort is 18-19 and 17-18. So, right, so the students in the standard cohort that we're going to use to comprise our completer list are folks who completed during those 2 award years. And then the earnings that we'll be using are from 2021 and 2022. If the department has to expand to a 4-year cohort, right, then they're going to be using students who completed between 15-16 and 18-19 across that 4-year award spread, and they'll be using earnings between 2019 and 2022. The red numbers just highlight that for the first 3 years for which these debt to earnings rates would be calculated, earnings data gathered from the pandemic, right, 20 and 21, will be part of those calculations. If you've got a 4-year cohort, they will be part of the calculations for the standard 2-year cohort, at least in the very first year. The other thing that this chart sort of highlights, and sometimes it takes folks a little bit to really wrap their brains around this, but again, it really highlights the extent to which the department will be using data from years that precede the effective date of this regulation. So the regulation becomes effective on July 1st, 2024, presuming it does not get blocked or otherwise held up. And what you see is for years, the department will be using data that was baked, cooked, whatever phrase you want to use, prior to the effective date of the regulations. Even 3 years out, I mean, we just didn't have enough room to go out. I think it's for the first 6 years, but you can see even in 26, 27, all of the costs and debt information is from years well ahead of 2024, right? And that'll be the first time that the department starts to use earnings from 2024. And what that means is if you use the standard cohorts and standard calculations, what that effectively means is for the first 3, 4, 5, 6 years that this rule is in effect, there is nothing you can do to impact the cost and debt information that's going to be used for the calculations. Think of it this way, and this is a fairly extraordinary thing to point out sometimes to folks. If on July 1st, 2024, you could say, we are going to start offering all of our programs for free on a go-forward basis for the next 4 or 5 years, it would not prevent you from, or your programs from potentially losing eligibility or otherwise being sanctioned, right? Because in 24, 25, 25, 26, 26, 27, the costs and debt information being utilized by the department for purposes of these calculations, it's already been cooked. It's from prior to 2024, right? And again, the earnings data also largely precedes 2024, at least until you get to the 3rd year that the rule's in effect. Now, it's for this reason in part that the department rolled out with the final rule a transitional rate concept, and I'll talk about that in a minute. Okay. Well, how do you know if a program is failing in any given year? What are the thresholds established by the department? We talked about how they're going to calculate this DE rate. So the department's going to determine whether a program fails the DE rates test in any given year in accordance with this threshold, right? So if the annual DE rate is greater than 8%, or if the numerator is positive and the denominator is 0. So sometimes you can have a situation where there are actually no annual earnings and you have a very small numerator, even if it's a pretty small loan payment. The fact is the department's trying to say, look, if you got a goose egg in the denominator, if your graduates have zero earnings, even though that technically makes for a rate that's lower than 8%, you would still be failing, right? That does occasionally happen, but I think for most folks, the thing that you're going to see is you're going to see a number, north of zero, and what you want to do is stay at 8 or less, right? That's the key. Over 8, and you would fail the annual DE rate. But to have a failure overall, and this is really important, you have to fail, your program has to fail both the annual DE rate and the discretionary DE rate. Let me say that in another way. If you can pass either one of these, if you have a passing annual DE rate or a passing discretionary DE rate in a given year, then your program passes. And remember, I was talking about the reason they invented the discretionary DE rate is because you had certain programs that were very expensive, like medical and law programs, that were failing the annual DE rate, notwithstanding the fact that their graduates were making a fair amount of money, well in excess of the poverty guidelines, right? And had enough left over ostensibly to service their loans as well. So that's why the department came up with this variation. Very short, inexpensive programs with graduates who make very little money may fail the discretionary DE rate, but they may pass the annual DE rate. The important point here is, in any given year, if you can pass either annual DE rate or the discretionary DE rate, then you're passing. You only fail if your annual DE rate is greater than 8%, right? Or the annual loan payment's positive and the median annual earnings is 0, and the discretionary DE rate is greater than 20%. So really what you want to look at, and here there's another variation again, if you've got a numerator that's positive and a denominator that's negative or 0. But really what you're going to be thinking about when you look, if you start projecting numbers, is you want to make sure that at least on one of these, your annual DE rate or discretionary DE rate, you're below the required threshold. And hopefully what you're seeing is a 4 or 5 instead of an 8%, and a 10 or 11 instead of a 20%. But if you do fail both of these, then for that given year, you have failed the DE rates test. Now let's take a deep breath. Let's talk about this other metric that the department has introduced. So it's not this whole scheme doesn't rely strictly on the debt to earnings rates, even though that is the one that has been there through all 3 versions. This earnings premium is new. This is the first time that we've seen it in this rule. So just like with the debt to earnings rates, every year, for all those Title IV programs, the department's also going to calculate an earnings premium. The earnings premium conceptually is much, much simpler. So that median annual earnings that we just calculated in connection with the DE rates, that same number, which is the median annual earnings for your cohort, right, that we used for the DE rates, we're going to use it here again. So this is not a new number. This is the same. This was the denominator, right, from the annual DE rate, the median annual earnings. And what the department's going to do is it's going to go out and find a number that it basically equates to, this is people with no college, what they make. So what we're saying is we're going to look at the median that graduates from your program are making, and we're going to look at the earnings for folks who have no college at all, no post-secondary education. No college is just my easy way of saying it, right? And we're going to calculate the difference. And if the folks graduating for your program are making less or equal to the folks with no college or post-secondary education at all, you're upside down and you fail. That's it. It's conceptually pretty easy, right? So again, we're going to calculate the median annual earnings for the folks graduating from your program. We're going to look at what folks who have no post-secondary education at all are making, and we're going to subtract one from the other. And if your program graduates are making less, in other words, we don't think your program is adding any value, and we shouldn't be funding it for Title IV purposes, right? But as is always the case, the devil is in the detail, and I'm not going to go too far into it. If you really want to hear me go into this, you can go back and listen to my comments on the proposed rule when this was first introduced. But let me just point out a couple of problems right out of the gates. And at the heart of it is that, here, I'll just go back a slide. The heart of it is that the median annual earnings and the earnings threshold, in my view, are not an apples to apples comparison. Right. And the department's sort of dismissive of this criticism in the commentary to the final rule. But I think it is a very serious concern, and I think it's one that's going to be raised without question in litigation. So where does that second number come from? When we say, what are people making who don't have any post-secondary education? Are we talking about people who are in the same tight geographic area where your graduates are located? Because remember, your median annual earnings number That's the actual earnings of people who graduated from your program. So if you've got a small program and you are in Central Valley, California, I lived out in Merced for a few years, small town. So let's say I'm in Merced and most of my graduates are still hanging around in the Merced area, then my expectation is their earnings are going to reflect the earnings of folks who are in Merced. Right? So where does the earnings threshold come from? First of all, the department isn't calculating a new number because candidly, it would be almost impossible for them to do that. If you think about it just from a data standpoint, how are they going to go out and figure out what folks with no post-secondary education throughout the United States and all these different geographic regions are potentially making? They really don't have a way to do that. So what they had to do was they look around and said, well, is there some agency in the federal government that's already calculating a number that we think we could borrow for this purpose? So they came up with a number from the Census Bureau. So their earnings threshold is based on the median earnings for working adults aged 25 to 34 who either worked during the year or indicated they were unemployed, i.e. not employed but looking for and available for work, when interviewed with only a high school diploma recognized equivalent in the state in which the institution is located or nationally if fewer than 50% of the students in the program are from the state where the institution is located or if the institution is a foreign institution. Okay, so let's talk about the apples to apples issues here. First of all, your graduates, their earnings are being measured generally 2.5 to 3 years after they graduate, right? So at best, they've had 2.5 to 3 years in the workforce to practice their profession. But the earnings threshold is looking at individuals who have potentially been out in the workforce much longer, 25 to 34, right? So you could have someone who has been out there practicing in their profession for 10 or almost 15 years, right? As opposed to 2 or 3. So that's an apples to apples problem. Secondly, at best, right? Here, let's use the California example, right? If all of my students who graduate hang out in Merced area and stay in California, right? Then in this case, they would be using data at the state level. But what that means is they're comparing the earnings from my graduates who are primarily in the Merced region, right, with the earnings of people from 25 to 34 across the entire state of California, including, for example, San Francisco and Los Angeles and Silicon Valley, right? So there becomes a real issue there because they're looking at my actual graduate earnings in a relatively small town rural environment versus a statewide metric. But the biggest challenge, I think, when you look at this is the fact that, and this is not entirely clear when you first read this definition, but look, it says we're just looking at the earnings of people from 25 to 34 who either worked during the year or indicated they were unemployed when interviewed. So what we're talking about is folks who are either employed or obtaining unemployment benefits and actively seeking employment, which they have to do to get those benefits, right? So folks who are, as the federal government says, in the labor force. But when the department calculates your median annual earnings for your program, they're taking everyone who graduated for your program. So if someone has decided not to work or has pursued a different profession, if they're staying home with the kids and have no earnings, they still get thrown into your earnings calculation. But here they're excluded from that calculation. So we're not looking at everyone 25 to 34, as is the case with your completers when they calculate your earnings data, your median earnings number. Instead, what they're just looking at is folks 25 to 34 who are actively working or in the labor force, which again creates a real problem because this is supposed to be, in theory, an apples to apples comparison. A lot of folks commented on this, as you would expect, during the proposed rule public comment period. And in the commentary to the final rule, the department acknowledges that, quote, individuals who are not seeking employment or who are unable to find employment over a full year due to disability or incarceration or for other reasons, i.e. staying home, don't want to pursue employment, are not included in the calculation of the earnings threshold. Then the department states, Ed was unpersuaded by the many commentators who expressed concern that program completers who are disabled, are incarcerated, or choose not to seek employment are included in the program's median annual earnings, but would not be considered part of the labor force that goes into the Census Bureau's ACS survey and therefore are not part of the earnings threshold calculation. So in other words, the department said, well, we're just not troubled by it. I need to take a deep breath, but this is a problem. I think this is a problem, and my expectation is it will be raised in litigation and elsewhere, right? By the way, the department does include in the final rule the national earnings threshold. So if you're tuning in next week when we're talking about projecting rates and you're trying to figure out how you think, first of all, if you can come up with sort of a proxy for your median earnings for a program, then you can use these numbers to try to see where you think you would pan out. And there are also places, I think in the proposed, maybe in the final rule and elsewhere, where you can get these same numbers at the state level. So that's what you can do to sort of try to figure out how your earnings premium may stack up. As you also might imagine, this is primarily this EP metric. And you remember at the outset, I mentioned that this is a huge problem like for cosmetology schools, right? The vast majority of the failures for cosmetology programs under their impact projections were the EP rate, not the debt to earnings rate, because their students aren't taking a lot of debt or cost to get through the program. The problem is they aren't showing a lot of earnings, and that could be for a lot of reasons. If they are women and minorities, they may be subject to wage discrimination. They may be underreporting their earnings because many of them are self-employed. I mean, there are a lot of things that go into that. But at the end of the day, if you've got a program with low earnings or low reported earnings, right, the EP or earnings premium measure is a problem. If you are a medical or I'll say law program or other program, you may have issues with the debt to earnings rate potentially, but you probably don't have an issue under the EP, right? It's really going to be an issue more for programs with graduates with lower earnings. Okay, so each year the department will determine whether a program fails the earnings premium test in accordance with the following threshold, which I highlighted earlier. Basically, if the earnings premium is 0 or negative. So once again, if your folks are earning, if the median annual earnings for your program is equal to or less than what we think is the folks with no college earnings, then you would fail the EP test for that year. Okay, again, taking a moment to collect at least myself. Now let's talk about reporting requirements. In this next segment of the presentation, let's say you're an institution and you think, well, look, we have done a great job in determining a cost and debt sort of profile for our programs relative to the earnings of our graduates, and we're not concerned about failing these tests. We're not concerned about the department labeling our program. First of all, great, and I hope truly for as many of the institutions out there as possible that this is the case, right? But I want to highlight here in this next segment that these obligations, the reporting obligations, are independent of the performance of your programs, right? Because this is the segment that really gets at your responsibilities in providing data to the department so that they can even crunch these numbers in the first place. And there's a lot to think about here. Okay, so institutions will be required to report an extraordinary array of data to the department. And I'm going to go through it in some detail. I don't like to get too detailed in presentations, but it's really important to me that you all appreciate the scope of what's going to be required here. So I did a little paraphrasing, but I didn't cut any corners. I wanted you to see everything that you're going to have to provide. The reporting obligations generally fall into 3 categories or buckets. You have Title IV program data, all student data, and data for completed and withdrawn students. So that's sort of an additional bucket at the end. As you would expect, the department also retains the right to collect any other information the secretary requires the institution to report. Okay. An institution, there is an exemption here, and this is similar to the one we talked about earlier. An institution is not required to report if it has not offered any group of substantially similar programs with 30 or more completers in total over the 4 most recent award years. So you may recall we had 2 institutional exemptions at the outset. One was for institutions in U.S. territories or freely associated states. They still have to comply with the reporting obligations. The second was for these really small institutions. So they are largely exempted not only from Subpart Q and S, but also from the reporting obligations, right? And again, here's where the department, I knew it was in here somewhere, indicates that they expect about 700 institutions may fall into this bucket. So before you start, working with everybody and pulling all of this reporting together, you probably want to run the numbers and see if you think you would be exempt or not, right? I mean, because this is going to be a lot of work. So you want to find out if you're going to be one of these 700 institutions. Okay, so let's talk about the data that must be required. And keep in mind, this is in the regulation. You've got the citation here at the bottom of the screen. And you can go back through each of these on our slide in time. But for each GE program and eligible non-GE program, right? So if it's a Title IV eligible program, it is covered. You have to report this information for the most recently completed award year, or I'll say the covered award year. That's the lead-in language in the regulation, but in our initial reporting period, you're going to have to report for more than one award year. And then on a go-forward basis, it'll just be the most recent award year. But at any rate, for the covered award year or award years, for each Title IV program, the name, SIP code, credential level, and length, whether the program is programmatically accredited, and if so, the name of the programmatic accreditor, whether the program meets licensure requirements or prepares students to sit for licensure exams in a particular occupation for each state in the institution's metropolitan statistical area, the total number of students enrolled during the most recently completed or covered award years, including both recipients and non-recipients of Title IV. So I just wanted to highlight a couple of things here, but one of the things right out of the gates is, while the DE rates and the earnings premium measures are calculated only on qualifying completers, which remember means someone who got some Title IV, the reporting obligations extend beyond that, right? So they're asking for data for purposes beyond just crunching these numbers. And finally, whether the program is a qualifying graduate program, remember that's one of the special programs with a clinical experience, whose students are required to complete postgraduate training programs. Couple other things just to highlight here. One of the things we've been talking about with some of the big, we represent a handful of service providers that manage platforms that are used by institutions of higher education, in addition to primarily representing colleges and universities directly. But one of the things they've already started to reach out to us about, and I'm sure they're hearing from some of their college and university clients, is whether or not the systems that they maintain have some of this data. And I have no doubt that many of them do. But I wanted to highlight that my expectation is many of those systems, and some of them were designed to comply with the 2014 Gainful Employment Rule, but many of them are not going to include data points like whether a program is programmatically accredited or whether it prepares students for licensure for each state in the school's metropolitan statistical area. So what you're going to have to do is figure out, reach out to these folks, you can tell I'm from the South because I figure things. What you're going to have to determine is the extent to which those platform providers or service providers can help you out of your systems generate these data points. And my expectation is there will be a handful that they can't provide. And so then when the department starts to come out with its guidance on how it wants you to consolidate and report all of this data for all of these programs and students, you're going to have to determine, how do we marry data out of different systems? And in some cases, it may be that new data has to be created, right? Because I just really don't know. This metropolitan statistical area data point, I don't know how many institutions track that or have that kind of information in existing systems. My guess is not very many. So there's going to be work that has to be done for certain in preparing for reporting this data. So this is for programs. Now let's talk about what they want for every student in each one of those programs. Information needed to identify the student in the institution, the date the student initially enrolled, attendance dates and attendance status, enrolled, withdrawn, or completed during the award year. Enrollment status, meaning for full-time, were they half-time, as of the first day of the student's enrollment. Total annual cost of attendance. The total tuition and fees assessed to the student for the most recent award year. And the residency tuition status by state or district. Okay, second slide, 2 of 2. For each student, they also need the total annual allowance for book supplies and equipment from the student's cost of attendance, the total annual allowance for housing and food from the student's cost of attendance, the amount of institutional grants and scholarships dispersed to the student, the amount of state, tribal, or private grants dispersed to the student, the amount of any private education loans dispersed to the student for enrollment in the program that the institution is or should reasonably be aware of, including private ed loans made by the institution. That's separate from grants made by the institution, right? So in order for the department to get that debt number, they really want to know about private education loans. And my guess is many of you are not capturing private education loans. Now, in some cases, they're asking for this data for award years, as we mentioned earlier, going back almost a decade. You may have no way of reconstructing private education loans, right? But you will have to do the best that you can to try to provide all of these data points. And on a go-forward basis, in order to comply with the rule, you're going to need to start trying to capture these data points for every student and to marry them together so that you can process them and present them to the department. As I'm sure many of you are appreciating, this is asking a lot already. How about for students who withdrew or completed during the covered award years. So the date the student completed or withdrew, and part of the reason for this is, the department has indicated a desire to try to start calculating withdrawal rates at institutions or something along those lines, completion rates at a federal level using a new metric. They haven't detailed how they want to do that yet, but they're starting to gather the data to do it. Total amount of student received from private ed loans for the program that the institution is or should reasonably be aware of, right? So that seems sort of duplicative in a way. But remember, this is for the program, not necessarily just for a single award year. Total amount of institutional debt the student owes any party after completing or withdrawing from the program. Total amount of tuition and fees assessed the student for the student's entire enrollment in the program. So I just want to highlight again, some of these statistics are a little different. We're not looking at just what was assessed in the prior award year. What we're saying is for a student who completed or withdrew in the covered or prior award year, we want data across their whole program. So the total amount that they took on in loans, the total amount that they took on in cost, right? The total amount of allowances for book supplies and equipment included in the student's cost of attendance for each award year in which the student was enrolled in the program, or a higher amount if assessed by the institution. So something else you're going to have to potentially figure out is, not only how to track their COA, but how much was actually assessed for these costs. And then finally, the total amount of institutional grants and scholarships provided for the student's entire enrollment in the program. Right. So again, the stuff on the prior slide, a lot of that data, we'll go back to it. For each student talks about just for a particular award year, and this is for folks who've completed or withdrawn. Now we're looking for data points across the entire program. Right. For qualifying graduate programs, the standard expectation in the law is that for those programs, institutions will report all of that data that I just went through for every program and every student for the 2nd through 8th award years prior to July 1st, 2024, right? So that's for 7 award years by July 31st, 2024. I'm going to show you a graphic on the next slide. For all other programs, the standard expectation is that institutions will be required to report all the required data for the 2nd through 7th award years by prior to July 1st, 2024, by July 31st, 2024. So just to be clear, I want to, your eyes are not deceiving you. The expectation is that 30 days after this rule takes effect, you will be reporting data for all these programs and all these students across multiple prior award years, right? And the department and the rule, just to also be very clear, says, hey, institutions shouldn't complain. They've got 9 months to get ready. So from the department's perspective, you are being notified now that this obligation, you can't say, well, the law became effective July 1st and we only had 30 days to do this. I mean, the department's been very clear. They said, no, this hit the Federal Register in October of 2023. Schools had 9 months to get ready. So don't expect any sympathy from the agency. Just to give you a quick perspective, right? Because I know sometimes the 2nd through 7th and 2nd through 8th award year stuff can be kind of wonky to wrap your brain around. So if you elect to participate in the standard reporting, and I say standard because there's a transitional option that I'm going to hit on next, which my guess is most of you will want to take advantage of. But if you elect to participate in the standard reporting, right, you would be required to report by July 31st of 2024 data for the award years 17-18 through 22-23. And you look down here at the graphic. So you see all the way off to the side, I've got July 1st, 2024. That's our effective date, right? So the first prior award year is 23-24, and then we march backward. The second prior year award year is 22-23, and I go all the way back to the 8th prior award year, which is 16-17. So for most programs, remember, you have to provide by that July 31st deadline all that program and student data for the 2nd through 7th award years. So you can see that's 17-18 through 22-23. If you've got one of those qualifying graduate programs, it would actually be 16-17 through 22-23. Right, so that's 1, 2, 3, 4, 5, 6, 7 award years for a qualifying graduate program going back all the way to 16-17. And in subsequent years, by the way, October 1st is the deadline for reporting the data for the most recent award year. So I will say one thing to keep in mind is this sort of massive data production obligation is just in the very first year. After that, I mean, there's still a lot of data produced even for a single award year. But on an ongoing basis, you would just be by October 1st of each year providing the data for the most recent award year, which is certainly a lot less than 7 or 8 award years. So your CLARIAC, your crime statistic report is due on October 1st, and now it would also be your gainful employment data reporting date. All right, so let's talk about the transitional option. So the department recognized, particularly in the face of a whole lot of heated commentary to the proposed rule, that asking for 6 or 7 or 8 award years of data right out of the gates in 30 days, even with a 9-month lead time, is a lot. And also, there's just the significant problem that many institutions aren't going to have a lot of this data, particularly for things like, private grants or private education loans going back 8, 9, 10 years. Certainly, they're not required to house that data in most cases under any federal or state law. And in fact, many institutions, of course, are being encouraged to release that data and delete it so that it couldn't be subject to some sort of cybersecurity attack, right? So the department, in part for that reason, and also trying to address the concern that schools aren't really able to do anything to impact their rates for the first several years that this rule would be in place, has come up with this transitional rate concept. So what they're saying is, if you would like to, for the first 6 years for which DE rates and the earnings premium are calculated, and the significance of that 6 years is that's how long it's going to take for the rule, the cycles, to catch up to today, right? Data that's being created as of July 1, 2024, when the rule goes into effect. So for the first 6 years, institutions could elect alternatively to only report for the 2 most recently completed award years, which would be 22-23 and 23-24. It's unclear, based on the way the law reads, whether or not both of those award years would be due by July 31st, or if 23-24 would be due by October 1st. I'm not sure. My expectation is the department's probably going to want everything as soon as it can get it. But at the latest, it would be October 1st for the second year. I would anticipate that, particularly because they've already feel like they've done you a service here, that they're going to want both of those award years to be reported by the July 31st deadline. You're still reporting a lot of data for all those programs and all those students. You're talking about 2 prior award years worth of data. But, another reason I would expect 23-24 to be put in on October 1st, of course, is that it's going to be really hard to finalize all your data in 30 days because 23-24 will have just ended, right? So actually, the more I think about it, the more I think maybe the department will allow 22-23 by July 31st and then 23-24 by October 1st. I think maybe that does make more sense, right? But you're still, by October 1st of next year, you're coming up with 2 award years worth of data for all those programs and all those students. So what should we do? Well, for my money, it probably makes sense to accept the transitional rate for several reasons, right? I mean, first of all, if you take the standard rate, there's a much higher reporting burden because you have to go back and get all of this prior year data together by next July 31. Also, if you select the standard route, you are unable to impact your costs or debt data for years to come, right? Because the department, presumably, if you report all the back data for those 6 or 7 award years under the standard reporting obligation, they have everything they need to calculate your rates using the standard methodology for the next 6 years. They've already got it. So why would they subsequently elect to use a truncated or transitional methodology? And if that's the case, if once you go standard, you can't go back, that also means that you're locked in. They've got that prior data, and that's what they're going to be using. And it's the example I gave earlier. You could stop charging anything for all your programs on July 1st, 2024, but you've reported all the back year data. That's what they're using. And for the next 6 years, they've got what they need. And you're not going to be able to impact those cost or debt numbers in the numerator of the DE rates. The one thing I'll note that probably falls in favor of the standard reporting is that it's possible 5, 6, 7 award years ago, your programs may have been significantly less expensive. So, if you have recently increased the cost or debt profile of your programs, you might actually say, well, we've run the projections and we think that, for the first 4 or 5 years at least that these things are calculated, we'll be fine. It's not until the last 2 or 3 years that we increase the price of our program, and now we're potentially going to be in trouble. So we would rather wait for the program for 4 or 5 years, get through that period, and maybe in that interim time we come up with a new program or an alternative or some other strategy. But, we're concerned that because we increased the program significantly in the last year or two, if we use that cost and debt profile from those last couple of years, we're going to fail. So even though that creates opportunity for us potentially, we think we would be better off going with the standard reporting. That's about the only reason I could think potentially to use the standard option. So the transitional, it's the opposite of all those things. You have a lower reporting burden. You have the opportunity to impact cost and debt data in the near term. Right now, it's October of 2023, which means we're already, about halfway through the 23-24 award year, which is the second of the 2 award years that would be part of the transitional reporting. And so you might have limited ability to impact the first calculation cycle. But the second calculation cycle is going to be based on 23-24 and 24-25 under the transitional model. And if that's the case, you've got lots of time to think about what you want to do this spring and then the entire subsequent award year, right? And so you might actually be able to have a real impact on the costs and debt profile. Not a lot you can probably do about earnings, but the cost and debt profile, you might really be able to do something positive. Okay, let's talk about some reporting riddles. The department moved through this process, meaning creating this whole rule, very rapidly. I think that's a reflection that their priority one was just to get the thing out the door. I think many of us who review these kinds of rules on a routine basis have noted that there are an increased number of sort of errors and vagaries and things like that, which largely we think just reflects the speed with which this whole thing. They were also concerned about a government shutdown. So they really hustled to get it out October 10th as opposed to, say, the end of the month, right? And and that may be a problem for them in litigation, by the way, for a variety of reasons. But there are also some things that just don't quite add up. We have a few answers. There are others where we don't have answers. Our expectation is over the coming months, the department's going to have to create a ton of guidance for institutions, which is what they did in 2014, right? I mean, there were all kinds of webinars and handbooks and things that came out that you'll want to try to key into, or whoever's responsible for this thing at your institution will need to key into. So riddle number 1, institutions may not have all the data required, particularly if you elect the standard reporting option, which requires information, in some cases, almost a decade old, right? The department does have an answer for this one. So for any award year, if an institution is unable to provide the required data, it must provide to the department with an explanation that's acceptable to the secretary. And this has been the case in prior versions of this rule. Quote, in such instances where institutions are unable to comply with these reporting requirements because the institution was not required to retain the records, under this regulation, they'll have an opportunity to explain its inability to comply with part of the reporting requirements. So the department anticipates this problem potentially and has even spoken to it. And that quote is from the Federal Register, for the commentary that accompanied the final rule. Okay. Riddle number 2. It's unclear how institutions are expected to report this data to the department. I'm anticipating some of the questions that you might be asking. I have no doubt in the past, in 2014, there was a process by which institutions created these huge batch data files and uploaded them to the department. The department will almost certainly, and this is a quote again from the Federal Register actually, the department will provide institutions with guidance and training on the new reporting requirements, provide a format for reporting, and enable our systems to accept reporting from institutions beginning several months prior to July 31. So a couple important points here. One is they're going to be putting out a ton of stuff. Whoever's responsible for this, form your reporting team and have them watching for this guidance. But the other thing that's worth noting here is the department is going to try to get their systems up and running so that you don't have to wait until July 15th to start reporting this data next year. You could ostensibly get it in June or May, even before the rule becomes effective. Now, if you choose to do that and it's then enjoined and then it is then struck down by court, you may have just reported a bunch of data to the department that it will never require. But you're going to have to decide what you want to do there. There's some pros and cons. I would caution against waiting until the last minute. The department systems can be overwhelmed, and if folks are reporting data for literally millions of students all on July 30th and July 31st. Well, ask your IT folks what they think about that, but my guess is they'll say let's not wait. There appears to be an incongruity, make sure I say that right, between the standard reporting periods and the years for which data would be required to calculate the DE rates per the department's example. Aaron, what do you mean by this? So I'm really nerding out here and evidencing that I spend way too much time looking at regulations and commentary. But, earlier I mentioned in the proposed rule and in the final rule, the department indicates that it will need data as far back as award years 15, 16, right? But the standard reporting time periods, which they also specify in the regulation, only calls for data going back to 17, 18. So I got a nifty graph. This is a version of what you saw earlier, remember? So if you look, you got data periods for the first year calculations per the NPRM in the first column, right? So these are the data periods for the first year calculations. This is where the department said, these are the years that we're going to be looking at. Remember, and you saw sort of a version of this originally in that first column. So we said for 24-25, the first time the department turns the crank on this regulation and starts to crunch these numbers, the standard 2-year cohort is going to be 17, 18, 18, 19. And then, and again, they give very specific examples in the proposed and final rule. And then they say the standard 4-year cohort would be 15, 16 through 18, 19. Now, if you've got a qualifying graduate program, it goes back even further, right? But they're saying for all normal programs, if we have to expand to the 4-year cohort to get your 30-plus completers, then we're going to be looking at data between 15, 16, and 18, 19. But then if you look at the reporting section of the rules, they say very specifically in the first year, so by July 31st of 2024, 2025, and then adding on a year on October 1st, what we're going to get from you is data from 17, 18 through 22, 23. Even qualifying graduate programs under the reporting section are only supposed to report back to 16, 17. So here is the great question, la gran pregunta. How are they going to have the data they need to run the standard 4-year cohort, much less the qualifying graduate program cohorts, which would require data for students who completed in 15, 16 or earlier, if you're only reporting to them data going back to 17, 18? I don't think it stacks up. So I think what's going to happen is we're going to see at some point down the line the department come out with some guidance to try to resolve this. By the way, in the final column here, just to highlight, if you choose the transitional reporting period, you're only producing 22, 23, and 23, 24. Maybe the answer to this riddle is no one actually reports under the standard reporting timetable. Maybe 100% of institutions or virtually 100% elect to do the transitional reporting, in which case this is a non-issue. But it's very interesting to me that there was just this incongruity between sort of the years they said that they were going to use as the basis for the calculations and the years for which they were planning to get data. It's unclear what earnings information will be used for the transitional rates or how it will be obtained. What do I mean by that? So under the 2014 GE rule, there was a transitional concept for the same reason, right? The Obama administration said, look, we understand we need to give institutions some mechanism by which to impact the performance of their rates. It seems unfair that on the day this rule becomes effective, their programs are basically rendered ineligible and there's nothing they can do about it. Okay. So under the 2014 rule, transitional DE rates were calculated using more recent cost debt data, but earnings from the standard cohort. And the reason the department had the earnings from the standard cohort is because under the 2014 rule, there was no leniency around the data reporting. Everybody still had to report all the required data. But what the department says is, again, for the first few years, we'll take debt and cost information from your most recent graduates and compare that to the earnings from the standard cohorts, for the folks who graduated back when they were supposed to graduate in the regular cohort, right? Here, again, the department suggests that earnings data will come from students who completed during the standard cohort. So what we're anticipating is, they're going to graduate back during the standard completer period, and we'll look at their earnings for the denominator, but then we'll take cost and debt information from a different group of students, right? The folks who graduated in just the last couple of years. But the problem is, in this case, as opposed to 2014, the department has said, well, you don't have to report all those back years of data. You're only reporting data for students who graduated in the last 2 years. So the great question in my mind is, how is the department going to know who completed in those prior award years during the standard cohorts? If I'm only reporting data for the last 2 award years, 22, 23, and 23, 24, how does the department know who completed my program in 17, 18, and 18, 19? In other words, how do they come up with the list of students for whom they need to get earnings? Right? Maybe they use NSLDS. I don't know. Or maybe they're still going to, are they going to send you a completers list for you to review? It's fascinating to me. So we'll have to get that figured out at some point down the line as well. All right. So that brings us to our second secret word, which is 5. It's the word 5, which is similar to the number 5, but with letters. So right now, again, you should see a little box popping up off either to my right or to my left. I'm not sure where it would be on your screen. And you're going to see several words, and there will be radio buttons next to each one of those words. One of them, hopefully, will be the word 5. And I would ask that you click on the little radio button next to the word 5. So our first secret word was it's. This secret word is 5. This secret word is 5, okay? Hopefully you've clicked on that radio button, particularly if you're an attorney looking for CLE credit. Okay, moving right along. Reporting was a lot. I know you've been through, I think, two of the harder sections here. I mean, digesting all of these metrics and how these calculations are going to work is really tough. And then just from an institutional standpoint, you might be popping the Alka-Seltzer because getting through those reporting requirements is tough as well. Now let's sort of take a breath and talk about the annual process. And then we'll talk about the department's website. And then we're going to get into those consequences of failure. Okay, so here's a little flow chart for you. The annual process is really not that complicated. The department compiles for each program a list of all students who completed during the applicable cohort period, right? And then they're trying to figure out who the qualifying students are. So they're pulling out anyone who was excluded, and they're tagging the folks who got some form of Title IV. And that tells them they graduated in the right time frame, and we know that they are supposed to be included on this list. And then, at this point too, they'll make the call, do we have at least 30 in the 2-year spread? And if we don't in the 2-year cohort, then we'll expand to 4 years and see if we've got at least 30 there. And if they have at least 30 in the 4-year cohort, then they move forward and they provide that draft completer list to the institution. And give the school 60 days to, quote, correct the information reported by the institution on which the list was based. Interesting way of phrasing that. So if you made a mistake previously, now you can come back and correct that mistake. But importantly, this is an opportunity for the institution to vet the list, right? And make sure that there's not some errant student there, or potentially someone who didn't actually complete or something like that. That final completer list goes to a yet to be named federal agency, again, the earnings agency, we're calling it for purposes of this presentation, to obtain the median annual earnings of the students on the list and the number, but not the identities of students that could not be matched. Let me say that again, and I'll get into why that's important in a second here. But so the department's not going to get back a list of names and how much they made. What the department's going to get back is the median annual earnings for the cohort that it sent over to the earnings agency. But then also they're going to get the number of students that couldn't be matched by the earning agency. So let's say on the completers list there were 60 students. That goes over to the earnings agency, and the earnings agency comes back and it says, we couldn't match 5, so we only had earnings data for 55 of them. I don't mean that there were only 55 who had earnings, right? I mean, the list would include somebody who reported a 0 earnings. But I mean, if there were 5, like they just couldn't match, it's not in our system. So we only had earnings for 55, right? Then the department gets the median of that 55, whatever that median earnings number was. And also, again, the earnings agency says, and there were 5 that we could not match. So once the earnings information is received back, the department makes any needed adjustments and then calculates the DE rates because it already has the numerator. And so now it's got the denominator. It can also now calculate the earnings premium because it's got that median annual earnings number, and it already has from the Census Bureau what those earning thresholds may be. So what about this adjustment thing? So, and this is appropriate and a good break for schools. If the earnings agency is unable to match one or more of the students on the completer list, right? I was just talking about that. Then this is the example where they report back to the department to say, here's the median for the cohort, and we couldn't match 5. Then the department will exclude from the median debt calculation, so the numerator, the same number of students with the highest loan debts as the number of students whose earnings could not be matched. So in other words, they're going to adjust the numerator. The denominator comes back, 5 students couldn't be met. And so here's the example the department gives. If the earning agency is unable to match 3 students out of 100, then the department will order your 100 completers, right, by the amount of debt, and then it's going to exclude from the numerator, from the debt calculation, the 3 largest loan debts. So that's good. That's what we would want. That's a good break. Also, if the earnings agency ultimately is unable to retrieve earnings for at least 30 students, then the department won't move forward with the calculation. So remember, we always got to have at least 30. So if the department starts to build the completers list and they don't have 30 in 2 years, they expand to 4. If they can't get 30 in 4, they stop. Similarly, let's say they get 33, right, across the 4 years. And so they send the completers list to the earnings agency, and then the earnings agency says, we can't match 4, so now we're under 29. And that's all we've got. We only have earnings data for 29 students. Once again, the department stops. I also want to highlight, this is different from the institutional exemption that we've talked about a couple of times for small schools that don't have at least 30 graduates from substantially similar programs over the last 4 award years. That's like an institutional exclusion. This is a different program by program exclusion. If the specific cohorts in a given year for a program don't get above the 30, both with regard to debt and earnings, then the calculation gets put to the side. Okay, so what's the department going to do with all this data, even for programs that have really strong numbers? So beginning on July 1st, 2026, this was another innovation in the final rule that breaks in favor of institutions and is really significant to appreciate. So the department's going to start, you got to start reporting in 2024. The department's going to start working to calculate these numbers as quickly as it can. It's indicated it hopes to get these first round of DE rates and earnings premium data out to schools, in the first half of 2025, I think, certainly before the second cycle starts, I assume would be its primary goal. But it won't be until July 1st, 2026 that the department will establish and maintain a new program information website that will include extensive information about institutions and their educational programs. So this new program information website is the centerpiece. This is the thing that the department's really going to use to deliver all of this. The new website will be the foundation for all institutional disclosure, acknowledgement, and warning requirements. And by the way, I'm going to talk about this a couple more times, but I want to draw a real hard distinction between these 3 concepts. Disclosure requirements are not sanctions. Everyone has to make certain disclosure requirements for all of their Title IV programs, even if they're great and they perform very well. The student acknowledgments are a form of sanction that we'll talk about in a little bit that applies to graduate degree non-GE programs that are failing, with failing DE rates specifically. And the warning requirements are a form of requirement that applies to failing GE programs, right? So these are different. Everybody does the disclosures. The student acknowledgments are specific to graduate degree non-GE programs, and then the warning requirements are specific to GE programs. But they all kind of feel the same, and it would be easy to muddle them a little bit because it all comes down to, hey, we've run these numbers, we put a bunch of stuff on the website, and now you've got to make sure that people are going to the website and seeing it in varying degrees, right? But it is important to keep in mind the distinction. Okay, it's unclear, by the way, how this website and the data displayed will interface with College Navigator, College Scorecard, or any of these other websites. A lot of people highlighted that during the public comment period. The department came back and said, several commenters suggested that the department provide the information via a single centralized website, such as the College Scorecard, rather than develop a separate website for the proposed metrics. And the department's response to this, I don't mean to smile, but it said, merely posting the information on the College Scorecard website has had a limited impact on student choice. This is the department saying this in the commentary. Consumer information is most likely to impact choice when tailored to the applicant's personal context. We seek to improve the information available to students with several refinements relative to the information available on the College Scorecard. But what makes me chuckle here is, we've developed this enormously complex rule, right, that's going to require an extraordinary amount of effort and resources on the part of institutions to report all of this data, right, and potentially be impactful, all right? And the department's going to calculate all of these numbers and put all this machinery in place, et cetera. Institutions, their programs could lose Title IV eligibility. Throughout the preamble to the final rule, in many cases when objections were raised, the department has said, look, we understand there are some concerns, but it is so urgent to get this data out on this website where students can view it that it outweighs these various concerns. And then buried in the commentary is this acknowledgement that, the truth of the matter is, when you post information on websites, at least our experience to date is it really has very limited impact on student choice. So it's fascinating to me that this entire framework is based on the notion that, that disclosures to students are impactful and important. And then there's sort of this tacit acknowledgement that, but a lot of students really don't go to the websites and it doesn't seem to really affect consumer choice. Of course, the department's response is going to be, yes, but we are creating information here that is, quote, tailored to the applicant's personal context. And that's why it will be different in this case. So let's talk about what's going to be on that website. Per the rule, this data must be included for every Title IV program. So this, per the law, will be on that website. The published length of the program, total enrollments in the most recent award year, total for tuition and fees and for books, supplies, and equipment, if the student's completing in normal time. Of enrollments during the most recent award year, the percent who received a direct loan, private loan, or both for the program. So that private loan data is pretty important to the department. Median loan debt and median earnings. So these are the things that the department is calculating, right, for just completers or for completers and withdrawals. We'll see how the department cuts it. Any programmatic accreditation and the name of the accreditor. And then finally, those debt to earnings rates and earnings premium measures. Now, what's interesting is the law does not actually specifically say the department's designations of high debt or low earnings have to be on the website. But the department sort of doubled down on that in the commentary to the final rule. A lot of people said, look, why are you making these value judgments? Just put the data up there. It could potentially be misleading. Some students don't care about this kind of stuff, et cetera. And I think there's a lot of merit to a lot of those arguments. And the department doubled down and said, look, we think these are simple, easy to digest labels, and we're going to stick with them. But it is worth noting that the law does not require the department to actually use those phrases, right? Data that may be included for every Title IV program. Again, no requirement or mention of these designations that the department has suggested they will be using. But here's the data that may be in addition to the must. Primary occupations that the program prepares students to enter, the program or institution's completion and withdrawal rates for full-time and less than full-time students. For completers, median total cost of tuition fees, cost of books, supplies, and equipment, and net costs. Loan repayment rate for students or graduates who entered a repayment on direct loan program loans. And whether program graduates must complete post-graduation training and obtain licensure to be eligible for independent practice. And, this is hand in hand with the changes the department has made in the recently finalized certification and recertification rules, particularly around determining state licensure obligations for programs and making that information available. Okay, so the department's indicated it will provide further information and announcements regarding the specific contents of the website, and this also may impact your reporting obligations. So if they decide to expand what they want, they might go back. And remember, they reserve the right under the reporting section of the law to ask for stuff beyond just what's specified there already. An institution must provide to the department such information about the institution and its programs as the secretary prescribes through a notice published in the Federal Register. The secretary may conduct consumer testing to inform the design of the website. I mean, to be fair, needs change, and the department may change what it is looking to obtain or disclose year over year. On the other hand, it is, I think it could potentially be quite frustrating to schools if the department in 3 or 4 years starts asking for data points that schools aren't presently recording or acquiring, such that, if 5 years from now the department says, well, we want you to start producing this for past award years. And you say, well, we don't obtain that information, so we don't have it. So, my hope is that the department will really work hard on figuring out, what the combination of data points that they need would be, and that would settle so that schools can create not just reporting machinery, but also recording machinery to ensure that they have all the data that they expect they're going to need. Okay, so first, this is the department's website. They're going to put all that stuff up. Now let's talk about how you're going to tell students about this website. In the first section, disclosures and distribution, again, not a sanction, not a consequence. This is just these requirements are requirements that apply to all institutions and all programs. This is just your baseline disclosure and distribution stuff. So first of all, institutions have to provide a prominent link to the department's program information website for its program on any web page containing academic, cost, financial aid, or admissions information about the program or institution. So I'm sure we're going to need guidance here, because if you are like me, I think, well, pretty much every page on my website contains academic, cost, financial aid, or disjunctive, or admissions information about the program or institution. What's interesting is in 2014, I think there were some ways they did this better and some ways worse. On the one hand, in 2014, it was more specifically just the program. So if you had a generic page about the institution that dealt with financial aid opportunities, you did not have to include a prominent link to the program information website. I mean, I think there is a real question here. If I offer 200 programs and I have a basic page on my website about financial aid, is the expectation that on my financial aid website, I have to include 200 links to the program information website about each program? Can I include a single link for my institution that then shows all the programs. I mean, there's some stuff there that's going to have to be figured out. Again, lots of figuring from the South. The other question, though, is whether or not the question, I should say, but the other thing that I think sort of broke in favor of institutions here is back in 2014, the department also required that you include these links in marketing materials. And it was really challenging because ostensibly the idea was you had to include links to the website for GE programs, like if you had a billboard that advertised the program or a radio spot. And I think as a practical matter, there was a lot of feedback that went back to the department and said, look, first of all, how are we supposed to put links on, billboards and in radio spots? And also, is any student listening to a radio spot, assuming students listen to the radio, by the way, or Spotify or wherever you might be putting this, are they really going to follow that link? And my expectation is the department just backed off of that. There's probably some discussion in the commentary I missed. But the good news is this framework really is focused on institutional websites and not more broadly on just marketing materials. The bad news is it seems to be more broadly stated, and it's a little unclear, how if you've got on your website just a generic page about admissions or financial aid, et cetera, like how are you posting all of these links? Incidentally, the department may require an institution to modify its webpage if the information's not prominent, readily accessible, clear, conspicuous, or direct. So you're going to want to know what the department's expectations are. Institutions, so let's talk about how do you get this information prospective students. So the good news is if you've put it on your webpage, now let's talk about your onboarding, orientation, enrollment processes. So the good news is if your programs are all solid and everything's passing, you got no issues with DE rates or earnings premium, then this is really just a make available disclosure. And the department in general, its consumer information disclosures are sort of fall into two buckets. One is make available disclosures, which means you got to make this information available to students on your website or in your catalog or in something you hand them, but you don't have to directly give them the disclosure, and you don't have to require them to go to the website or acknowledge that they've been there or something like that. So if your program is in good shape and you're not failing anything, right, the information's got on the department's website, you've put the links on your website to their website. The other thing you have to do is provide the relevant information to access the department's program information website to any prospective student or third party acting on behalf of a prospective student. So parent, before the prospective student signs an enrollment agreement, completes registration, or makes a financial commitment to the institution. So my read on this is, look, somewhere in the onboarding materials that you're providing students before you sign them up or take any money, right, you've got to include access to this website. Okay, I think this should be pretty manageable. You're just going to have to integrate it into the admissions process. Institutions must provide the relevant information to access the department's website also to any enrolled Title IV recipient prior to the start date of the first payment period associated with each subsequent award year in which the student continues enrollment at the institution. How do you read this? Well, I read this to mean you also got to make an annual disclosure. So there are basically 2 points in time in which you've got to integrate providing students information about how they can access this webpage, even if you're the department's webpage, even if your programs are all great. One is prior to them signing up and giving you money, right? And the other is for all current students on an annual basis before the start of the award year. So, I've not thought too extensively about this, but my quick and dirty would be I'm probably creating a consumer information disclosure that I give out maybe in the late spring every year, right? And I send out some from, we test our security system and we do 2 or 3 other things, but that might be a good time. So that would be prior to the next award year, or you could do it over the summer, et cetera. I mean, you'll have to figure it out. But I do think what this is going to require is you've got to integrate this into your onboarding process for prospective students, and you've got to figure out a way to ensure that prior to the start of award year for all current students, you're getting them this information about how to access the department's website. You don't have to record that you don't have to show that they've gone to the website and viewed it, but you've got to show that it's actually getting out there. Okay, so let's talk about timing, because I think there's a little bit of a question mark here. I've already been asked this question by a couple of clients. So if the department should launch its program information website before July 1st, 2026, what's your obligation as an institution, right? Because the law says beginning July 1, 2026, the department's website is going to do this, and you got to do all this other stuff with the disclosures. It's unclear. What's interesting is in the commentary, the department states that it has, quote, specified that the requirements under 668.43D, that's the consumer information section where these requirements are housed, and the acknowledgement requirements, right? And we'll get to that in a minute, under 668.47, 668.605 are not applicable until July 1st, 2026. However, if you actually go to 668.43D, it says the department will launch its website on July 1st, 2026. But there's not any clear exemption. The text doesn't actually say institutions don't have to start making the disclosure until that point in time. It just indicates that that's the date that the department's website will go live. So the question is, what if theoretically the department gets its, it may have calculated all its rates. It may get everything up and running by, let's say, January 1st, 2026. Do you as an institution, can you just wait until July 1st? I think institutions are going to have to think about this and decide, because there would seem to be some risk involved, right? You may run the risk of, for example, an AG claim or class action or some other challenge like a bar defense claim. If the department's website is out there, all the requisite information is on it, including potentially if you have a failing program, right? And you're not disclosing the information to the student yet. I could see a borrower or a student saying, hey, this really important information was out there. This was a material omission. You should have told me that it was failing. And I would not want my only response to be, well, in the regulations, it says the department's website won't go live until July 31st. I don't know. So I think you're going to have to think about how you want to handle that. Okay. So that was just, again, disclosures without regard to program performance that are required for every program and every Title IV program in every institution. Okay, now let's talk about consequences of failure, and we'll start with non-GE programs. So each year, upon finalizing the debt to earnings rates and the earning premium calculations, the department goes through that process we talked about earlier. The department will issue a notice of determination to the institution, informing it of the DE rates and earnings premium measure for each of its programs that have been calculated, as well as whether each program is passing or failing and the consequences of that determination. Okay. Now, I have this consequences chart here because, again, I mentioned earlier, I think this can get a little confusing, and I just wanted to try to help folks see visually. So for non-GE programs, and remember, proprietary institutions don't have non-GE programs. So what we're talking about over here is for public and private nonprofit institutions. Undergraduate degree programs that you offer, there is no consequence. So if your undergraduate degree programs have failing DE rates, failing EP rates, now you still got to make that website available to students each year and before they, when they're prospective, and maybe they go to the website. So I don't mean to suggest that that's inconsequential, but that's not a consequence for failing. That's, again, something that everybody has to do. There's no additional consequence for undergraduate degree programs, non-GE programs, undergraduate degree programs at private, nonprofit, public institutions that are failing. If you have a graduate degree program, so again, if you're a public, private, nonprofit, and you have a graduate degree program, and it has a failing debt to earnings rate, I'll talk about this in the next slide, it has to make these student acknowledgments. Okay, so that is a sanction, an additional sanction beyond the just standard disclosures for graduate degree non-GE programs. If you have a GE program, so this is a certificate, remember, diploma offered by anybody, public, private, nonprofit, proprietary, or any program offered by a proprietary institution, right? The sanctions are student warnings. The program could lose its Title IV eligibility, and you could be subject to a period of continuing eligibility for new or substantially similar GE programs, all right? So we're going to walk through each one of these, but I wanted to sort of summarize these for you quickly. Okay, so first of all, let's talk about the student acknowledgments. So we're talking about non-GE programs, and we're talking about specifically graduate degree non-GE programs. And here the law is explicit, and it's written in a way that I think is quite clear. So prior to July 1st, 2026, this requirement should not apply. But beginning on July 1st, 2026, if a non-GE graduate degree program has a failing DE rate, prospective students must acknowledge that they have reviewed the department's website before the institution may enter into an agreement to enroll a student. Okay? 2 or 3 things to highlight here. First of all, note that the acknowledgement requirement is limited to prospective students. All right, my read on the law, the guidance is there is no consequence for current students. This acknowledgement requirement only applies to prospective students in non-GE graduate degree programs. Second, there is also no consequence for non-GE programs that fail the earnings premium test. Again, it is specifically if you have failed DE rates. I don't expect that most graduate programs at public and private nonprofit institutions will have an issue with the earnings premium test. We talked about that previously. That really is a problem for programs that graduate students with very low earnings. Now, if you've got a graduate certificate program, maybe it becomes a problem. But for the most part, we expect most graduate programs, if they have a problem, it's going to be with the DE rates. And again, it's only the DE rates for which these sanctions apply. The student acknowledgement requirements for non-GE graduate degree programs, again, are based solely on DE rate performance. The department's going to administer and collect the acknowledgement from students through the program information website. So you're going to have to get them there. If you have a non-GE graduate degree program that has a failing DE rate and is subject to these requirements after July 1st, 2026, you'll have to get the student there, right? But the department will actually collect through an interface, presumably on its website, the acknowledgement. Prospective students will be required to complete the acknowledgement so you'll have to continue doing that until the program has achieved a passing DE rate, or 3 years have passed since Ed notified the institution that the program had failing DE rates. What does that mean? So let's say you got a graduate degree program that has pretty small completer cohorts, right? And you get over 4 years above 30 in a given year, so they calculate numbers for you, and you fail that DE rate. But then your program shrinks, and over the next 3 or 4 years, you're below 30, even with an extended 4-year cohort, and the department performs no calculations. What they're saying is there does come a point where you sort of time out from the sanction, right? So if 3 years have passed since the department notified the institution that the program had failing DE rates, at that point in time, you would be able to cease requiring students to go through the acknowledgement. Okay. One of the other questions here that's really fascinating is it's unclear how and to what extent institutions that don't utilize enrollment agreements will be required to comply with the acknowledgement requirement for non-GE graduate programs. In other places in this rule, and we're going to see this in just a few minutes, the department has very specifically said you can't, sign an enrollment agreement, you can't register them, you can't have them take on a financial commitment, you can't disperse Title IV. And here, it seems very hard to believe that they sort of mistakenly or through oversight only referenced signing of an enrollment agreement, particularly because the vast majority of traditional institutions that would be subject to this, public and private nonprofit institutions, don't use enrollment agreements. On the other hand, it's very hard for me to imagine that the department would buy that as an excuse. In other words, if you were to say, well, we know we had the failing DE rate and we know we're not allowed to, sign an enrollment agreement until somebody goes to the website, but we don't actually use an enrollment agreement, so we just haven't been doing anything. And even if the department, for some surprising reason, were to say that that's okay, I again would be very concerned about an allegation by a student that was a material omission as a basis for a bar defense claim, or to a plaintiff's attorney as a basis for a misrepresentation claim under state law or an AG action or something like that. So, I think schools are going to have to be real thoughtful about being cute over whether or not they actually use an enrollment agreement. Also, I'll just note that under the most recent bar defense rule and the Obama era bar defense rule, breach of contract is a basis for a bar defense claim, and the department, particularly, I remember distinctly in the preamble to the Obama era bar defense rule, when that breach of contract basis for a bar defense claim was first introduced, they said, look, we consider a contract to be potentially your catalog or, other information beyond just a sort of traditional enrollment agreement. So the other concern I have here is that the department has been willing in other contexts in the past to say we consider a contract to be for enrollment ostensibly to be something beyond just a traditional enrollment agreement. Okay. By the way, the department says it will enforce this rule through audits, program reviews, or other investigations. All right. Third secret word, o'clock. O'clock. O''CLOCK. So once again, there should be some sort of child window popping up to my left or to my right, and there will be those radio buttons, and you will have several words. If you are an attorney, or just for fun, if you want to identify o'clock and click the radio button next to it, that would be great. And if you are an attorney seeking continuing legal education, that will enable us to continue giving you this critical CLE credit, which we want to be able to do. All right, so secret word number 3 is o'clock. Please click on the radio button next to that word. Okay, let's talk about consequences of failure for GE programs. So first of all, once again, beginning on July 1st, 2026, and I do believe the law is quite clear on this limitation, an institution will be required to provide a warning to current and prospective students if its GE program could become ineligible in the next award year for which DE rates or the earnings premium are calculated. Okay, that's sort of a weird way to think about this. But as a practical matter, what that means is if you fail year one, then right away institutions will be required to provide the required warnings because 2 years in a row of failing and your program loses Title IV eligibility. I'm going to get to that next as a consequence. But the first thing that you as institutions are likely to see if you have a GE program that is failing is this student warning requirement, which is why I wanted to start here. But the really critical idea is I think sometimes folks say, well, you don't lose Title IV eligibility unless you fail 2 out of any 3 award years for which rates are calculated. And I mean, the first response to that, of course, is, yeah, but the bummer is all of the calculations are based on prior year data that's already been cooked, so there's nothing we can do about it. And then, the second response is, as a practical matter, if we only fail 1 year, then we have to start making these student warnings. And if you've got GE programs, whether you're a proprietary institution or public or private nonprofit with non-degree programs that are important to you, if you've got those GE programs, these warnings, which we saw in 2014 under the prior GE rule, literally, this is not hyperbole, the department designed the warning that schools had to use in 2014, and at the top there was a big red stop sign with like an exclamation mark in it. So my expectation is whatever the department creates on its website, it will not encourage students to enroll in the program. I'll just put it that way. So if you fail year one, now you have to start getting all of your prospective and current students have to go to the website and see this disclosure that the department puts together. And again, my expectation would be it is not very student or prospective student friendly from an enrollment cycle perspective. Okay, so an institution may not sign an enrollment agreement, complete registration, enter a financial commitment with, or disperse Title IV funds to a prospective student earlier than 3 business days after the institution delivers the warning and until the prospective student completes the acknowledgement on the department's website. So there are 2 things going on here. First of all, I mean, the way to think about it is if you've got a failing GE program, you can do nothing with the prospective student, right, until you take care of this business. And there are 2 concepts here. One is you have to give the warning and 3 business days have to pass before you can do enrollment or other activities, right? And the student actually has to go and complete the acknowledgement on the department's website, which again will be run by the department. An institution may not disperse Title IV funds to a current student until the student completes the acknowledgement on the department's website. So prospective students, you're going to have to do all of this, current students as well. Also, if a student or prospective student does not enroll for more than 12 months after receiving an initial warning, the institution must provide the warning again. Now, this really isn't so bad. Under the old rule, it was a much tighter time frame, like a matter of days. Here, if somebody's gone for a whole year, the idea is, okay, you need to show them again, unless, since providing that initial warning, the program is passed, both the DE rates and earnings premium for the 2 most recent consecutive award years in which the metrics are calculated. In addition, and this is a pretty onerous requirement, I think. I mean, I understand the intent behind it, but I'm not sure how schools are going to comply with this. It's schools' obligation to provide the English language warning as well as translations for students and prospective students with limited proficiency in English. I mean, I'm not so concerned about, obviously it's important to the extent the warning is important, which the department certainly thinks that it is. I'm sure others do as well. It's important that students actually be able to understand it. I think the bigger challenge here is from a compliance perspective, what does it mean for a student to have limited proficiency in English? Just from a compliance perspective, how comfortable can you be that a student understood the warning, or after the fact, if they have an issue and raise the issue or submit a bar defense claim or something like that, and they claim they have limited proficiency and didn't get the translation, how are you going to be able to document that they did understand it? I don't know. Just, again, for me, it's less about the obligation of coming up with the warning in other languages, though that is not small. And it's even more about how do you know when this has been triggered. So it's something else I think that's going to be a wrinkle that you're going to have to think through. Certainly if you have substantial student populations that speak limited English but speak some other language, you're going to want to have these warnings available in that language too, or risk having a problem. A warning that the program is not passed the department standards based on student debt and report. Oh, sorry. So this slide and the next slide detail the items that must be in the warning. And by the way, this is a little confusing, but there are two things going on here. I mean, one is you're actually handing something to the student, right? And then also the student is going to the department's website and seeing something, right? And this was a little confusing. I don't think it's perfectly clear, but that's clearly the case insofar as the department has rules around how you're supposed to distribute the warning to students and document that you did so. And then it's very clear that they're going to have something on their website as well that students have to go to and acknowledge. So there's sort of two things happening. So these are the items that have to be in the warning that you hand the student. A warning that the program has not passed the department's standards based on student debt and reported earnings, and that the program could lose Title IV access based on the next calculated metric. A statement that the student must acknowledge having viewed the department's website before the institution may disperse any Title IV aid to the student. A description of the academic and financial options available to students to continue their education in another program at the institution, including whether the students could transfer credits earned in the program to another program at the school, and which course credits would transfer if the program loses Title IV eligibility. So the department's not requiring that you have another program into which students could transfer, for example, but they are requiring that you tell them the answers to these questions. This is 2 of 2. An indication of whether if the program loses Title IV eligibility, the institution will continue to provide the program to allow students to complete and refund the tuition fees and other charges paid to the institution by the students. I'm not sure I understand why an institution would be obligated to refund tuition and fees simply because the program is no longer Title IV eligible unless it guaranteed the Title IV eligibility throughout the program. I mean, I understand the argument that I expect a consumer advocate or others might make that it's a de facto, the student won't be able to finish if they're relying on Title IV. On the other hand, as a contractual matter, typically most enrollment agreements aren't financing contingent for the student. In other words, the student has an obligation to pay the amount for the program, and if you've delivered the program to date and the student ceases to be able to finance the program, they may not be able to continue, but again, I'm not sure why you would refund tuition and fees. It's interesting. I think schools are going to have to be very thoughtful about how they want to manage this and, obviously talk to your counsel. An explanation of whether if the program loses Title IV eligibility, the students could transfer credits earned in the program to another institution in accordance with an established articulation agreement or teach-out plan or agreement. Again, there's no requirement that this be the case, but you have to tell the student whether it is or not. And finally, information to access the department's program information website. So clearly, we're talking about two different concepts. We're talking about the disclosure, the warning that you have to hand students, and then separately, the student then has to go to the department's website and is going to have to complete this acknowledgement. So let's talk about the distribution requirements. Any current student has to receive this warning no later than 30 days after the date of the notice of determination. So you get that notice of determination, the department says your GE program has failed, you got to move quickly to put this thing into place. 30 days is quick, right? Warnings to current students must be made in writing, by hand delivery, mail, or electronic means, and must be the only substantive content contained in the communication. So you can't send them this warning along with 20 other documents, right? Institutions should maintain documentation of their efforts to provide the warning. By the way, what's interesting is that's required by the department, but that's also very sound advice, and I would expect any counsel would suggest that you do otherwise. It's one thing to comply with laws, but if you can't demonstrate that you complied with laws, you got a problem, right? So you always want to be able to capture whatever you need to capture to demonstrate compliance. Let's talk about prospective students. So any prospective student or third party acting on behalf of the prospective student, so that could be a parent, uncle, brother, sister, must receive the warning at the first contact about the program between the institution and the student or the third party acting on behalf of the student. So, I know a lot of people would push back on this. This was a similar concept, or this similar concept did exist in the 2014 rule. For those of you who may not have dealt with it before, it's challenging because what it means is your admissions personnel or others have to be ready on the fly the first time somebody reaches out about a program for which there is a warning requirement to deliver that warning. And so you're going to have to train folks. You're going to have to figure out how to do that in an elegant way. We had folks who, they would be on the phone, a call would come in, and they would have the warning ready to go, and they'd say, hey, while you're here, I need to send you an email, something like that, right? Warnings to prospective students can be delivered by hand, email, or orally if contact is by telephone. And I know that's an attractive option, but I would just highlight that if it's done orally, it's very hard to document unless you're going to record all of those phone calls, right? But how are you going to show that this disclosure and warning was made? Now, keep in mind, the prospective student has to go to the department's website, right, and acknowledge that they've been there through the department's website. But just for purposes of documenting this initial disclosure, if you do it orally and you're not recording those phone calls, I'm not sure how you would be able to demonstrate it to the department. Institutions should consult the specific requirements for delivery and maintain documentation showing that the warnings were made. And there are some specific requirements in the rule. I didn't list them here. I've got almost everything here, but this is one place where I decided not to put it into the presentation. So depending on whether you're delivering by hand, email, or orally, there are some additional requirements as to when and how you can do that. So let's talk about losing Title IV eligibility. So the first step, your program fails a year, you got to start making those warnings. When could your GE program, actually lose Title IV eligibility? If it fails the DE rates test and 2 out of any 3 consecutive award years for which the program's DE rates are calculated, if it fails the earnings premium test and 2 out of any 3 consecutive award years for which the program's earnings premium is calculated. Now, there are 2 points I want to make here. The first is these are really independent of one another. So if you fail the DE rates the first year and pass the earnings premium, and then you fail the earnings premium the second year and pass the DE rates, your program does not lose its eligibility, right? These tests are essentially administered independent of one another. They are both ways that you can lose Title IV eligibility, but there's not a mix and match concept. The other thing I want to comment on is this notion of, it says, for which the program's DE rates are calculated. And this goes back to another comment I made earlier, and that is, if you have a program that fails DE rates in year 1, and let's say in year 2, your cohorts have been shrinking, and in year 2, the department can't come up with at least 30 students, even across the expanded 4-year cohort, and let's say that stays the case for 3 years, and then once again in that 5th year, let's see, is that right? 1, 2, 3, 4, yeah. In that 5th year, the department has enough students that it can calculate a rate, and you fail again. So you failed in year 1 and you failed in year 5, and in the 3 years in between, no rates were calculated. Your program would become ineligible. And that's because your program failed 2 out of 3 consecutive years for which rates were calculated. So in the years in which rates aren't calculated, it's like it's invisible. It goes away. The department calls it a no result, right? So it's just important to keep in mind, you can't lose eligibility as a consequence of having a no result, but you don't get back to becoming eligible. Now, by the way, there is a similar provision here that if enough years go by in between, the department actually invalidates that first year 1 calculation because it's so old, it becomes stale, right? Here I think it's 5 calculation years. So if the department does not calculate or issue a metric for a program for an award year, again, it's a no result. And then here's the point I was just making. In determining a program's eligibility, the department disregards any metric that was calculated more than 5 calculation years prior. Okay, so just keep in mind, there had to have been 5 years in between where the department ran numbers. So you can't get, if it was like year 1 and year 6, and in between all of those years you had no calculation, then I think the year 1 would have been thrown out by that point. Okay, period of ineligibility. And this is also a really important concept and a real consequence. So an institution may not seek to reestablish the eligibility of a failing GE program that it discontinued voluntarily, either before or after DE rates or the earnings premium measure are issued for that program, or reestablish the eligibility of a program that is ineligible under the DE rates or the earnings premium measure until 3 years following the earlier of the date that the program loses eligibility or was voluntarily discontinued. So what's the idea here? The idea is if you know that a program is failing and you failed 1 year and you expect that it's going to fail year 2, if you discontinue it voluntarily, right, presumably with that knowledge, or you actually get the second notice of determination and it's failed twice and now it's losing eligibility, you can't roll out a replacement program either that's the same or substantially similar for 3 years, right? And remember, substantially similar means any program that shares the same, I think it's on the next slide, the same 4-digit root. So if you're a small institution and all of your programs, though different, share the same 4-digit root, this becomes a real kind of problem for you. Now, your other programs can remain eligible, but it just limits your ability to roll out any new programs that would be within your area of expertise if they're all sort of fall in that 4-digit root, similar zip code, right? But what it also really suggests is the importance of understanding how your programs are likely to perform today, as early as possible, because you want to know now if you think programs are likely to fail, so you can start rolling out new programs and getting them approved before you even get a first round of calculations, right? I don't think the department could say if you roll out a new program before they've even calculated round one, that you are voluntarily discontinuing a failing program, because they haven't even run the first round yet, right? But after they run the first round of calculations and you are notified that you got a program that's failed at least 1 year, I think any point after that, if you discontinue that program voluntarily, they're going to say you're subject to this limitation. So if you assume the department is going to crank through the first round of calculations and start issuing notices of determination in late spring or spring 2025, what that means is you've basically got a year and some change to try to model the performance of your programs and figure out if you need to be rolling out replacement programs that are likely to perform in a better way. Right? A program is rendered ineligible if a program is rendered ineligible. So let's say you failed 2 out of 3 consecutive years, EP, earnings premium, or the debt to earnings rate, either one. Now you failed twice out of 3 consecutive years. So the program's participation in the Title IV programs, its ability to participate in Title IV, ends upon the earliest of, and this is an odd provision in the new rule, the issuance of a new ECAR omitting the program, the completion of a termination action of program eligibility, if an action is initiated by the department under Subpart G, or a revocation of program eligibility if the institution is provisionally certified. So, the department in the commentary says, institutions with programs that are not eligible as a result of failing GE rates, which I assume means DE or earnings premium, can appeal under Subpart G of Part 668 if they believe the Secretary erred in the calculation of the program's DE rates or the earnings premium. But an institution may only initiate an appeal under Subpart G if the department first initiates a termination action of program eligibility under Subpart G. If the department simply updates the ECAR or revokes eligibility directly for a provisionally certified school, then the appeal right would not exist as the law is written. And remember, your program gets bumped out of Title IV if it does any of these things. So, from my standpoint, I don't know why the department would ever initiate any action under Subpart G. I would just update the ECAR to indicate that the program's lost eligibility, and that appears to block any appeal right whatsoever with the department. It's not consistent with the sentiment in the commentary, but candidly, there are a number of places where statements in the commentary don't seem to completely reflect the way that the law is written. I don't mean to suggest that the department's being disingenuous. That might just be a reflection of the fact that they were trying to get this thing out very quickly to beat a government shutdown and other issues. But it certainly is the case that that's not what the law provides, right? It seems to me, again, that the department could simply update the ECAR and indicate that pull the program off the ECAR for everyone and never have to initiate a proceeding under Subpart G. Further, even if they did initiate a proceeding under Subpart G and you were allowed to appeal it, the extent of the appeal is strictly that the department erred in the calculation of the program's DE rates or earnings premium. So you can't argue that you think the rule doesn't work or that your students, let's say your program only educates women and minorities. You can't go in and say, well, the people in our program are subject to wage discrimination. So the reason that our earnings numbers are lower than the guys across town, or maybe we're in a rural area, as opposed to an urban area, so we have depressed earnings, none of that isn't a basis for an appeal. The only thing that's a basis for appeal is that you think the department got the math wrong, which candidly, I can just tell you from my sort of lawyer perspective, is a very hard thing to contest, right? I mean, my expectation is the department can run the numbers. The other thing that's worth pointing out is there really are no other challenge or appeal rights here, which is different from the 2014 rule, and that was widely commented on. A lot of folks pointed out in every stage of this process during neg-reg and comments to the proposed rule, that in 2014 the department went on about how, to ensure process for institutions and to, improve the accuracy of the numbers, it was important for the institutions to have a chance to look at the debt rate, the debt numbers and potentially challenge them. which was something you could do in 2014, or to come up with an alternative earnings appeal. Here, the department generally just is, I hate to use the word dismissive, but I'll just quote them. With the benefit of experience, other developments since 2014, and the inclusion of these rules of various safeguards against significantly inaccurate or underestimated completer earnings, we've concluded that the alternate earnings appeal of the kind the commenter suggested would be unreasonable if not arbitrary. So, the department basically says, yeah, we've been thinking a lot about it, and based on sort of, on balance, all of our experience and thinking, we just don't think it makes sense anymore. But what that means is there are extremely limited appeal rights in reality for institutions. So the last little segment, you're getting awfully close, we're going to talk about is certifications for GE programs. It's pretty quick and easy. As a condition of continued participation in the Title IV programs, any institution with GE programs has to certify that each GE program it offers is approved by a recognized accrediting agency or is otherwise included in the institution's accreditation by its recognized accrediting agency, or if the institution is a public post-secondary vocational institution, not many of you out there, but possible, the program is approved by a recognized state agency for the approval of public post-secondary vocational education in lieu of accreditation. Certifying that your program is accredited, all Title IV programs have to be accredited, and you already have to provide that to the department as part of certification and recertification. So I candidly don't see this as a significant lift. I think it's more about the department just ensuring that it's got you certifying over and over to eligibility, right? For existing GE programs, institutions will be required to submit the required certification by December 31st, 2024. Or if you happen to go through recertification and get a new PPA between July 1, 2024 and December 31, 2024, it will probably just be included, and you would just make the recertification as part of the overall recertification of your PPA, Program Participation Agreement. On a go-forward basis, institutions will be required to update the certification within 10 days if there are any changes in the approvals for a program or other changes for a program that render an existing certification no longer accurate. Okay, let's talk about timelines and action plans. First of all, this is how I expect all of this is going to play out, sort of putting everything together, right? So July 1, 2024, assuming that there's not a roadblock here like litigation or an election that gets in the way. July 1, 2024 would be the effective date of the new GE rule. July 31st would be the deadline to report at least 2 award years of data, even if you elect the transitional reporting. December 31st, 2024, by the way, and it is probably the case that between actually, let me revise this back to what I was saying earlier. So a little vague. It may be if you elect transitional reporting that by July 31st, 2024, you're just reporting 1 award year of data, 22-23, and then on October 1st of 2024, the department may allow you to report 23-24, right? The award year that would have just concluded. My expectation is they will clarify that and that will be allowed. That seems to make sense. Seems like it'd be a real lift to ask institutions to report all of this data for an award year that concluded just 30 days before. But just keep in mind, somewhere between July 31st, 2024 and October 1st, 2024, at the least, you're going to have to report 2 award years of data. So December 31, those initial certifications are due. January 2025 through June, I expect that's when the department's going to work really hard to get their first round of determination letters to schools. October 1st, 2025, you'll have report the most recent award year data. At that point, that'll be for 24-25, and that would be the second cycle starting. And then July 1st, 2026 is when the program information website is supposed to launch and institutions begin complying with disclosure, distribution, acknowledgement, and warning requirements. Let's talk about some critical points, action plans. Institutions should immediately initiate conversations among institutional leadership. This is our view, legal counsel, academics, and others, to determine who in the institution is going to be responsible for compliance with this rule. And my expectation is it can't be just any one entity, right? I mean, you've got to be evaluating the cost structure of programs. Academics is going to need to understand that, these financial value determinations are significant and programs may have to be redesigned to try to promote positive debt to earnings rate outcomes, which I know many of you in higher education, that probably makes your skin crawl. The notion that, you're having to design programs not to produce the best academic experience or most informed or competent graduate, but rather to maximize debt to earning performance in a calculation designed by the Department of Ed. Your leadership and legal counsel will probably be involved to interpret a lot of these things. And then, your admissions folks are going to have to be involved because there's so many disclosures and things that happen on the front ends. So the website, IT, you're really going to need a lot of folks to put this thing into place. Institutions should determine whether to elect the standard or traditional reporting and begin developing the reporting plan, keeping an eye out for guidance coming from the department. And finally, our very strong advice, and we're not trying to sell folks on anything. We do model and project rates for schools and have done that for a very long time. But whether you work with us or you do it internally, we think institutions should start working to model program performance because remember, even if you choose the transitional reporting, right now, we're already halfway one award year for the first cycle. It'll be based on 22, 23, and 23, 24. One of those award years is cooked, and we're halfway through the next, or almost, right? You have some ability potentially to affect that first year rate, those debt and cost numbers, but limited, because you only have about half of 4 quarters to deal with, right? But for the second year for which rates would be calculated, you've still got an entire award year that hasn't hit yet. And if you start modeling performance now, you can start determining whether or not there's strategies you want to put into place to ensure that your programs perform well. The other thing to keep in mind, as you're sort of looking towards reporting obligations and all those types of things, is the opportunity right now to potentially roll out newer replacement programs. Because keep in mind, just a few minutes ago, for GE programs at least, if you get that first year and they're failing, you're going to have a limited ability to roll out a new Title IV program in its place if it's substantially similar, right? So we think it's really important to try to come up with a way to model program performance that's realistic, and also to start thinking about strategies if you've got problem programs. All right, so here's our final secret word, number 4 on the day, somewhere. Somewhere. So if you've been paying attention, which hopefully you have, the 4 secret words were, it's 5 o'clock somewhere. And if you've made it this far through this presentation, it is 5 o'clock somewhere and you're probably due. So I appreciate your patience, appreciate you hanging in there. I know this is just a tremendous amount to take in. Again, you can watch this presentation again on YouTube where it'll be sitting for a while. I'm sure you can check out our desk guide. Come back next week for the next webinar where we go through these calculations in more detail and just revisit some of these concepts to help all of it settle in. If you need help, you're welcome to reach out to us. But this is a big and impactful rule, and it is really important that folks spend some time to get their minds around it. So also, if you're an attorney looking for CLE credit, look for that box out to my right or left, and please be sure to click the radio button that says somewhere. Just a couple of minutes here. We do have lots of materials. I've already mentioned this a couple of times, so I'll go quickly. But our resources page, you can scan that QR code, and all of our webinars and our white papers and disc guides and all the other things that we develop, including for the Gainful Employment Rule, will be on this web page. So you can find it all in one place. Our blog, we write about things all the time. You can get to that through the resources page. We do have a YouTube channel. It's on Thompson Coburn's YouTube site, and there's a playlist for higher education. And I think this is higher ed webinar like 70. So we've put a lot of time and effort into these over the years. And then we have these white papers. We have a desk guide out on the bar defense protocols for responding to bar defense claims, if you'd like to look at that. That came out recently. And again, the desk guide for gainful employment will be coming out soon. And finally, just keep in mind, we're not your attorneys unless we're your attorneys. And this is provided for informational and community support purposes. So with that, we're going to conclude this portion of the presentation, and we're going to move, if you're listening on November 7th, to the live presentation. We're now going to transition into Q&A. And if you're listening after the fact on YouTube, thank you for joining us. Hang in there, and we'll see you next time. Hi, okay, so hold on. It turns out we discovered when we finished the presentation that at 2 hours and 40 minutes, we actually need 6 secret words. 4 is not enough, right? So we're going to do 1 additional secret word right now, and then we're going to start the Q&A session, and then I'll give you 1 more secret word during the Q&A session. So your first additional or bonus secret word that I'm giving you right now is puppy, right? So it should show up on the screen. It says PUPPY, hopefully. And in addition to that, to your left or to your right, you'll see another box that's got a radio button. And next to that radio button is the word puppy, PUPPY. And if you will please click on the radio button that says puppy next to it, we'll make sure that you get your first additional secret word. And then finally, during the live Q&A session, I'll give you one more secret word so we can ensure that all those lawyers out there who are trying to get that continuing legal education credit get it and get what they deserve, especially if you sat through 2 hours and 40 minutes of presentation. You certainly deserve the CLE. So one more time, the first additional secret word is PUPPY. Okay? All right, say goodbye. Goodbye. On to the Q&A. Bye, everybody.